My learned friend is moving, it is not a fresh matter, my lord. This is your lordship is directed me to file the statement of objection. Or we are getting the file, my lord.
Fresh matters, Matra. Yes.
Lord,
Huh?
49.
Huh?
Of Maya, my lord, of exponent. Online.
I'm appearing for appellant 49.
Serial number 49 at the request of learned counsel, Srimati Maya TR. Release this matter. On 7th of November.
My lord, serial number 35. I am submitting on behalf of Sudarshan M, my lord. Kindly grant 2 weeks time, my lord. 35.
35. 35.
Where's Mr. Mantesh Patel?
Is
No objection. Serial number 35 at the request of learned counsel, Sri Sudarshan M.
please.
Release this matter on 5th of November.
Please.
Yes.
Milord, serial number.
ಇವತ್ತು ಎಷ್ಟಾಗಿದೆಯಾ ಇದು? ಎಷ್ಟಾಗಿದೆಯಾ ಇದು? ಇವತ್ತು ಇದೆಯಾ?
Non-compliance of which is objection for second time, CL number 1, Anand Ture.
Milord, 2 days time may be granted, my lord. The name of the accused to be mentioned, I will comply the order.
Finally, 2 weeks are granted at the request of learned counsel for the complainant for compliance of office officials.
CL number 2, additional government advocate.
2 weeks time may be granted.
It was finally 2 weeks at the request of learned government advocate.
CL number 3, for fourth time, YV
Milord,
Raviraj.
I'm the present standing counsel, and I have, last time my visit, I have cured almost most of that, except for the communication certificate. I have to get that from the department. Kindly grant me 3 weeks time. I'll send that to the Gulbarga and get it cured, my lord. Only communication certificate
3
has
weeks.
to be produced.
You want 3 weeks?
Yes, my lord, because I have to collect that communication certificate and
Finally, 3 weeks are granted at the request of learned counsel for the appellant for complaints of office officials.
my name may kindly be shown, my lord. I am Tirumalesham.
Name of Mr. Raviraj should be removed, is it?
Yes, he is no more the standing counsel for Gulbarga. I am the standing counsel.
Starting early, learned counsel Sri Tirumalesh.
Yes, my lord. M. Tirumalesh.
M for Mysore.
Yes.
M. Tirumalesh submits on behalf of the appellant that learned counsel Sri YV Raviraj is not on the panel of the income tax department
For Gulbarga.
at Gulbarga, and therefore his name may be removed, and the name of learned counsel Sri M. Tirumalesh may be shown in the cause list. Office is directed to accordingly show the name of learned counsel Sri M. Tirumalesh in the place of learned counsel Sri YV Raviraj. Yes.
Much of it.
Non-compliance of office objections for fifth time, CL number 4, Veerangoda
My
Malipati.
lord, I pray for a week's accommodation, my lord. It's only in respect of court fee, week's accommodation, my lord.
5th time.
It's only a court fee is left, my lord. We have informed the company, my lord, a week's accommodation. Needful.
Company ಏನ್ರಿ ಪ್ರಾಬ್ಲಮ್?
ಅಲ್ಲ ಎಲ್ಲದ್ರಲ್ಲಿ ಕಟ್ಟಿದ್ದಾರೆ, ಇದು ಒಂದು ಬೈ ಓವರ್ಸೈಟ್ 107 cases ಇದೆ, ಒಂದರಲ್ಲಿ ಓವರ್ಸೈಟ್ ಆಗಿದೆ.
Finally, 2 weeks are granted
Please.
at the request of learned counsel for the appellant for compliance of office objections.
Please.
CL number 5, Mantesh Patil.
Finally, 2 weeks are granted for complaints of office objections.
CL number 6, Sagar.
My lord, a week's accommodation, my lord, I had complied, further objection has been raised, I'll comply, my lord.
Finally, a week's time is granted at the request of learned counsel for the complainant
Please, my lord.
for complaints of office objection.
CL number 7, additional government advocate.
2 weeks finally, your lords. grant.
Huh?
2 weeks finally, lords may grant, my lord, for compliance.
Two weeks, finally, at the request of learned government.
Please.
Non-compliance of office objection for 6th time. Sanjay M. Joseph.
2 days time granted madam. Already complaint sir other part ಅಂತ ಹೇಳಿ ಅವ್ರ objection ಆಮೇಲೆ ಹಾಕಿದ್ದಾರೆ.
Finally, a week's time is granted at the request of learned counsel for the appellant for complaints of office objection.
Much.
For orders, CL number 9, Sanjeev Kumar C. Patil, memo for withdrawal of appeal.
The memo is filed by the appellant, my lord.
Huh?
The memo is filed by the husband, my lord. It is a divorce petition is rejected.
Huh?
The appeal is filed by the husband.
Huh?
Now he is not interested in, my lord, for. He has signed also.
Appellant, along with the learned counsel for the appellant, have filed a memo dated 22/10/2024, stating that the appellant is not interested in further prosecuting the appeal. Full stop. Therefore, leave is sought to withdraw the appeal. Full stop. Next para. The memo is taken on record subject to all just exceptions. Full stop. Accordingly, the appeal stands dismissed as withdrawn.
CL number 10, memo for withdrawal, party in person, GG Goni.
The petitioner party in person has filed a memo dated 30/9/2024, seeking leave of this court to withdraw the contempt petition. Full stop. Same order.
CL number 11, Sangan Goda V. Biradar.
Yes, my lords, I want to take paper publication, my lords.
ಮೂರ್ ಸರಿ ಆಗಿದೆಯಾ?
ಹೌದು ಆಗಿದೆ
ಹಾ?
ಮೂರು ಸಾರಿ ಕೊಟ್ಟಿದ್ದೀನಿ ನೋಟಿಸ್ ಆಗಿದೆ
A week's time is granted at the request of learned counsel for the appellant to file necessary application for substituted service.
CL number 12, Sangan Baswa B. Patil.
Appearing for the appellant in this matter, my lords.
Yes. Yes.
This is a matter, my lords, where the appellant was the person who has applied for the GNWC for custody of the child, my lords, minor daughter, which was refused on the ground that she is not economically independent to support the child. I'll take my lords to the judgment, what has been passed by the learned judge. Lordship may turn to ink paste.
One submission, may I request? Virtually, this, my lord, the appeal has rendered infructuous. The reason is, my lord, the daughter has already joined the mother. Daughter has joined mother, rendering, my lord, the very judgment, my lord, in favor of, my lord, the present respondent. Ineffective, because, my lord, there was a provision made for, my lord, allowing the child to, my lord, visit a place of mother during summer vacations. She attended, my lord, has SSLC, my lord, the final examination, and then had joined, my lord, the mother during vacations, and she is refused to come back. And, my lord, before this honorable court, there was a mediation held, my lord, and where, my lord, she has said she want to join, my lord, the mother, for which now, my lord, father do not want to object, because she is grown up now, my lord, aged about 15 years. My lord, now, my lord, insofar
Please
as
file a affidavit.
please, I would not, my lord, press for, my lord,
A week's time is granted at the request of learned counsel for the respondent to file necessary affidavit having regard to the fact that the respondent now contends that the child is now staying with the mother, and she has expressed her intention to stay with the mother. released this matter on 5th of November.
The connected matter is with regard to dissolution. Insofar as the alimonies and other arrangements to be made.
That will be insofar as
First matter.
MFA 202185 of 2022 is concerned.
So for second matter is concerned, is now my lord, wife and my lord, daughter both have decided to stay away against me.
Ah,
Now, since past 8 years, my lord, they are living separately. My lord, petition seeking dissolution of marriage, my lord, was had held against me. Now, my lord, it is only, my lord, since neither the wife nor my lord, the child is interested. At least. my
I'm
lord, my
sorry, my
petition-
lords. It is not that the wife is not interested. She is very much interested to join. I'll file my
After
objections, my lords.
After 8 long years, my lord, what she was doing for all these 8 long years, when I had, my lord, brought up, my lord, a minor child for 8 long years, she never even took a, my lord, burden of, my lord, filing a
anyway, that
petition.
has to be considered on merits, we'll see.
Along with, my lord,
Much of.
Seal number 13, Mahadev S. Patil.
This court, my lord, or last vacation, my lord, issued, my lord, notice through a bailiff, my lord. Because the respondent is not taking, my lord, service of notice, my lord. We are seeking custody of children, my lord. And she was not residing on similar address, my lord, he changing the address.
It is stated insufficient address. ಸರ್ವಾಗಿಲ್ಲ.
Or one address ದಾಗ ಇರಲ್ಲ ಸ್ವಾಮಿ.
ನಾವೇನ್ ಮಾಡೋದು? You will have to furnish the correct address, take steps.
My lord, my submission, my lord, in even before the
bailiff sent through the learned senior civil judge and J.M.C. Lingasugur shows that the notice would not be served as the address is insufficient. Full stop. Therefore, the appellant is required to furnish the correct address and thereafter take steps for service of notice. 2 weeks are granted to do the needful.
May I make a submission, my lord?
Yes.
My lord, even before the trial court, she was brought by the police, my lord. Even before trial court, my lord. She was brought by the police, my lord. She was not residing in a continuously changing address, my lord.
Because mat ನಡೀತಾ ಇದೆಯಾ?
ಇಲ್ಲ ಅಲ್ಲಿ ಇದು GMWC ಅಲ್ಲಿ ತೆಳಗಿನ ಕೋರ್ಟ್ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ
ಆಯ್ತು ಮುಗೀತು ಅದ್ ಕತೆ.
ಹೌದು ಸ್ವಾಮಿ.
At least if there was some matter and she is appearing in that matter, we could have directed the learned judge to ensure that there is service.
ಅದನ್ನು ಮಾಡಿದೇವು my lord. My lord, ಎಕ್ಸ್ಪರ್ಟ್ ಆಗಿದೆ ಸ್ವಾಮಿ. ಬಂದಿಲ್ಲ ಹೌದು, ಬಟ್ ಅಲ್ಲಿ ಕಸ್ಟಡಿ ಆಫ್ ಚೈಲ್ಡ್ my lord, ಕಸ್ಟಡಿ ಆಫ್ ಚೈಲ್ಡ್ ಎಲ್ಲ ಇಂಟ್ರಿಮ್ ಅರೇಂಜ್ಮೆಂಟ್ ಮಾಡಿದ್ರು ಫೋನ್ ಅಲ್ಲಿ ಮಾತಾಡಿ ಅಂತ, ಅದನ್ನು ಆಗ್ತಾ ಇಲ್ಲ ಸ್ವಾಮಿ. ಈ ತರ ಒಂದ್ ಅಡ್ರೆಸ್ ನಲ್ಲಿ ಇರೋದಿಲ್ಲ ಸ್ವಾಮಿ. Therefore, I request, my lord, her presence may be secured through police, my lord.
ಏನ?
Police through ನೇ ತರಿಸ್ಬೇಕು. May I pass on this, my lord?
Oh, see, these are not criminal matters.
But my lord, ಈ ನ್ಯೂಸ್ ಪೇಪರ್ ದಾಗ ತೊಗೊಂಡ್ರು ಏನು ಉಪಯೋಗ ಇಲ್ಲ, ಬಿಕಾಸ್ ಸೀಕಿಂಗ್ ಕಸ್ಟಡಿ ಆಫ್ ಚೈಲ್ಡ್, my lord.
You will have to give some information that this is the correct address. And thereafter, we will permit you to take steps.
My lord, she sometime residing in village, sometime she go to work for the Bangalore, my lord. ಈ ತರ ಅಲ್ಲಿ ಎಲ್ಲಿ ಇರ್ತಾರಂತ ಇವ್ನಿಗೂ ಗೊತ್ತಿಲ್ಲ ಸ್ವಾಮಿ, ಕಮ್ಯುನಿಕೇಶನ್ ಇಲ್ಲ ಸ್ವಾಮಿ. Because since 2022 we are making 2 ಸಾರಿ ಬೇಲಿಫ್ ಇದು ಆಗಿದೆ, ಒಂದ್ಸರಿ ನಾವು ಹೋಗಿ ಇದು ಮಾಡಿದೀವಿ ಸ್ವಾಮಿ, ಅಲ್ಲಿ ಇರ್ತಾ ಇಲ್ಲ, ಅದು ಈ ತರ ಪ್ರಾಬ್ಲಮ್ ಆಗ್ತಾ ಇದೆ.
What is the matter?
Custody of child, my lord, GMWC, my lord.
ಯಾರ್ petition file ಮಾಡಿದ್ದು?
Husband, my lord. The
That
father
has
is
been-
filed
has been dismissed.
please, my lord.
Has been dismissed.
Please, my lord. Even visiting right nu ಕೊಟ್ಟಿಲ್ಲ ಸ್ವಾಮಿ ಅಲ್ಲಿ.
The child is with the mother.
Mother, my lord. Communication
You have to
interim.
take steps in accordance with law, sir. You cannot do anything else. Yes, next matter, please.
Number 14, Veerangoda Mali Patil.
The connected matters, lordship has overruled the Office objection and interim order is granted. my lord.
Huh?
In connected matters, lordship has overruled the office objections and interim order has been granted. These are the beneficiary appeals.
Similar
my lord.
orders, huh?
Similar orders, all common judgment.
MFA 202721 of 2022 dated 14/10/2024, same one.
Seal number 15, Veeramgowda Malipati.
Office objection,
Same, my lord. That office objection,
Yeah,
same,
all.
same.
Yes.
Please.
same, 15 also same.
Seal number 16, additional government advocate.
But in this matter, my lord, I have to file dispensation application, my lord, for dispense the production of the certificate copy. And 1 week time may be granted, my lord, all other objections is complied. It was dismissed for default. Then liberty is given to me to
How can
comply.
we dispense production of certificate copy?
Because another connected matter, my lord, I filed that, my lord, certificate copy.
Ah,
Xerox copy is produced, my lord, that ground is, my lord, application is not filed. Office objection raised that only once.
week's time is granted at the request of learned counsel for the appellant to file necessary application seeking dispensation of production of the certificate copy.
Please.
Seal number 17, Arun Kumar Amargundappa.
Appellant in this case. My lord, notice issued through this court, my lord, is unclaimed by the respondents.
Unclaimed bere, refused bere.
Sorry,
Unclaimed adre, we can't take it as a service of notice.
yes.
ಅದಕ್ಕೆ ನಾವು ವಿಲ್ ಹ್ಯಾವ್ ಟು ಸಮನ್ ದಿ ರೆಕಾರ್ಡ್ಸ್, ಅವ್ರ ಇನ್ಫಾರ್ಮೇಶನ್ ಕೊಟ್ಟಿದ್ರಾ, ಇಂಥ ದಿವಸ ಬನ್ನಿ ತಗೊಳ್ಳಿ ಅನ್ಬಿಟ್ಟು ಅವೆಲ್ಲ ಆಗೋದಿಲ್ಲ.
Yes.
ರೆಫ್ಯೂಸ್ಡ್ ಅಂದ್ರೆ ಎಸ್, ಅನ್ಕ್ಲೈಮ್ಡ್ ಅಂದ್ರೆ ಆಗೋದಿಲ್ಲ. ಯು ಹ್ಯಾವ್ ಟು ಟೇಕ್ ಫ್ರೆಶ್ ಸ್ಟೆಪ್ಸ್.
My lord, in fact, my
Week's
friend,
time is
my lord,
granted to take fresh steps for
my
service of
friend is
notice or-
appearing, my lord, in connected matter,
ಯಾರು?
representing Mahadev Patil, my lord.
In the read court, my lord.
In the writ, before
Ah.
the writ court, there is one more petition, my lord, arising out of same
Ah,
issue.
hmm.
There, my lord, he is representing respondent number 2. Respondent number issuance of notice in respect of respondent number 3 may kindly be dispensed with, men. No reliefs are sought against him.
I will seek
Mahadev
instruction.
S. Patil,
ಹೌದು
Yes.
I will seek instruction, my lord. ಈಗ ಇಂಟಿಮೇಶನ್ ಮಾಡಿದ್ದಾರೆ.
learned counsel, ತಗ್ಬಿಡಿ ಅದನ್ನ. Learned counsel Shri Mahadev S. Patil, who appeared for respondent number 2 before the learned single judge, he is present in the court. Stop. The learned counsel is requested to take notice for respondent number 2.
I will seek instruction, my lord.
2 weeks time is
My lord,
granted to the
there is-
learned counsel to file wakalat. ಆಗಲ್ಲ ಅಂತಂದ್ರೆ you can say yes.
My lord, there is some urgency. It is a matter, my lord, where for the registered partition deed is set aside.
ಮುಂಚೆ ಹೇಳಿದ್ದು it will hold good for respondent number 3.
My lord, there is some urgency. Partition, registered partition is set aside under invoking, my lord, provisions of Senior Citizenship Act. Issue is covered by, my lord, decision of this honorable court.
Hmm.
And learned single judge, my lord, has committed error in taking a different view. I have, my lord, submissions to make on this. Now, my lord, based on, my lord, mutation entry, the mother, he is, my lord, about to sell the property. At least, my lord, an undertaking to that effect, if it is
Mother,
mother. My lord, mother has approached the senior citizen tribunal.
respondent number 2.
Yes, ma'am.
Ah,
She, my lord, stating, challenging, my lord, partition deed
ah,
entered in between 2 sons and, my lord, her. And they, in the partition, my lord, she has taken some gold ornaments.
Hmm.
It is admittedly, my lord, house property, which is, my lord, 80 into 10 square feet is a joint family property of, my lord, all the 3. There, my lord, 2 sons have got, my lord, equal share in the said house property. And she, my lord,
she also has a share.
she, my lord, she is also, she, my lord, parted with
She
share.
also has a share.
Yes, sir.
In law, she also has a share.
Yes. But, my lord, reasons, my lord, out of love and affection on both, my lord, sons. She parted with property. However, my lord, she is satisfied with the gold that has been issued. Now, my lord, in view of order passed by before the single judge, may I pass on. I am, my lord, I have undertaken, I am paying, my lord, monthly 10,000, a rental of I have hired, my lord, house in the name of my mother. And I am paying rent, my lord, regularly. However, she is not residing there.
I seek 2 weeks, my lord, because I have to instruct.
Already in the connected matter, learned single judge directed me to make some residential arrangements. I have hired a house and, my lord, I am paying rent regularly. May I request lordship to peruse single judge order passed in connected writ.
ಏನ್ರಿ, what is this? Huh? The better part of it, you people have kept in the partition.
She is admittedly, my lord, aged about more than 70 years. My lord, may I request to peruse?
Yes.
And I am also giving undertaking that, my lord, whatever, my lord, she demands in terms of money, my lord, I am ready to pay my part of responsibility. I am ready to pay it. And may I request lordship to peruse, my lord, single judge order in WP number. All that, my lord, proceedings are initiated at the instigation of my brother, who, my lord, who after, my lord, taking share, he sold, my lord, property in favor of some third party. And, my lord, said third party has also before the learned single judge. There, my lord, learned single judge has passed an order staying the very same order, which is, my lord, called in question before the third party purchaser was before the honorable court.
Saying what?
Yes.
Saying this is.
ಹೌದು
the same.
ಹೌದು.
Ah.
And, my lord, there learned single judge has stayed the order of tribunal. Very partition deed, which is not at all amenable under the provisions of Senior Citizenship Act to seeking
23/3/2023.
Yes,
Same order.
yes, ma'am. Same order. Petitioner is different. He is a purchaser from my brother.
ಅದು ಯಾವ್ದು 24/1/2023 ಅಂತಿದೆ.
Same ಅದರಲ್ಲಿ ಆರ್ಡರ್ ನಂಬರ್ ಸೇಮ್ ಇದೆ. ನಂಬರು ಆಮೇಲೆ ಡೇಟ್ ಎಲ್ಲ ಸೇಮ್ ಇದೆ. Date, my lord, there it is mentioned differently.
19/2022-23.
Same order.
How can it be?
Same. May I request?
Can the date be different?
Annexure E, ನಾನು ಇದರಲ್ಲಿ ಡೇಟ್ ಸರಿಯಾಗಿ ಬರ್ದಿಲ್ಲ, ಅವ್ರು ಟ್ರೈಬ್ಯುನಲ್ ಅವರೇ ಮೆನ್ಷನ್ ಮಾಡಿಲ್ಲ.
Is next week though, Swami, I will take instruction and make my submission before the court, my lord.
No, the apprehension is that you are now trying to
Yes.
dispose of the property.
Illa.
We will direct you to maintain status quo.
Illa, next week though, I will take instruction because I have.
Not take advantage, sir. And anyway, there is already an order of stay.
My lord, even he was not giving my lord maintenance amount also, my lord.
That is why we are saying, what is the big hurry? Why you want to dispose of the property?
Disposal ಮಾಡ್ತಾ ಇಲ್ಲ.
That is what we will record that one.
ಇಲ್ಲ I will instruction ತಗೊಂಡು ಆಮೇಲೆ
That is, we don't want to record your submission. We will issue a direction. Maintain status quo till the next date of hearing. Work.
my lord, next week ಇಟ್ಟರೆ I will make submission on this part, my lord.
The order has been stayed, sir, by the very same judge who has passed this order. ಕೊಡ್ರಿ ಅವ್ರಿಗೆ ಕಾಪಿ.
ಇಲ್ಲ ಕಾಫಿ ಇದು ಏನೂ ಇಲ್ಲ
ಇದೆ,
ನೋಡಿ. I will verify and make submission, my lord. I will verify and make submission, my lord.
Sir, it's already stayed, sir. There is an order. Please read it. The very same judge who has passed this order.
ಇಲ್ಲ ಅವರು ಇಂದಿರೇಶ್ ಸಾಬ್ರು ಮಾಡಿದ್ದಾರೆ, ಅದು ಸೂರಜ್ ಗೋವಿಂದ್ರ ಸಾಬ್ರು ಮಾಡಿದ್ದಾರೆ.
ಇಲ್ಲ ಸೇಮ್ ಜಡ್ಜ್ ಸಾಹೇಬ್ರ
ಸೂರಜ್
ಗೋವಿಂದ ಓದ್ರಿ. ಸೂರಜ್ ಗೋವಿಂದ ಜಸ್ಟಿಸ್ ಸೂರಜ್ ಗೋವಿಂದ್ರ ಬರ್ದಿರೋದು ಸ್ಟೇ ಆರ್ಡರ್ ಅದು ಓದಿ.
ಹೌದು ಸ್ವಾಮಿ, ಸ್ಟೇ
ಮತ್ತೆ?
ಆಪರೇಷನ್ ಎಂಟ್ರಿ petitioner shall make ಆಗಿದೆ ಸ್ವಾಮಿ. Released on my lord.
Learned counsel for the petitioner
appellant
appellant submits that the very same learned single judge who has passed the impugned order has thereafter stayed the order of the competent authority by order dated 13/7/2023 in writ petition number 2018886 of 2023. Full stop. That was a writ petition filed by some third parties who had purchased the property at the hands of respondent number 3 hearing. Who also had acquired rights over the said property under the same partition deed which was under challenge. Full stop. Next para. Consequently, we hereby direct the parties to maintain status quo in respect of the properties in question arising out of the partition deed dated registered partition deed dated
my lord
12th of June 2019 till the next date of hearing. Yes.
Liberty may be reserved for vacating filing, my lord.
Huh?
Liberty may be reserved, my lord, for filing
That
vacating.
is only till the next date of hearing. Yes. Huh? R3 refused ಅಂತ ಬಂದಿದ್ಯಾ? ಹಂಗಾದ್ರೆ ಆ ಸೆಂಟೆನ್ಸ್ ತೆಗೆದುಬಿಟ್ಟು the notice sent to respondent number 3 has returned with the postal shara not commercially refused. Stop. Therefore, notice is held sufficiently served on respondent number 3. Yes.
Let me permit it. Sir, the copy of the.
I'll sir.
Only learned counsel for the appellant is directed to serve copy of the appeal memo along with annexures on learned counsel. Please so and so.
CL number 18, Ravi B. Patil.
In this matter, my lord, connected matter, my lord, your lordship is directed to take notice to the other side, my lord. Copy is not served to them, my lord, by oversight. But today, in the due course of the day, my lord, will serve the copy, my lord. Your lordship have it on 5th, my lord, for
Even in
admission.
the absence of my lord, the copy, I am ready to my lord argue the matter because my lord, this is
So I
the
have to
8th
serve
time they
copy
are
to
seeking
the-
the time on very same point. My lord, this matter is already covered by the decision of this court, which has been affirmed by the Honorable Supreme Court.
A writ appeal file ಕೊಡ್ರಿ. Connected matter. this work board was represented?
Yes, yes.
Yes,
They have not preferred any appeal.
Huh?
They have not preferred any appeal.
Then why are you?
It is the state which is.
if the,
ಅವರೇ ಚಾಲೆಂಜ್ ಮಾಡ್ತಾ ಇಲ್ಲ ಅಂತ ನೀವ್ ಯಾಕ್ರಿ? Why are you taking this responsibility?
because our order is, my lord, set aside by the
So what?
single judge, my lord.
So what?
Knowingly, my lord, this
But
is a,
in your, contention of the deputy commissioner is that it's a property belonging to the work board.
yes, as per
Therefore,
the-
it cannot be converted. Work board is not raising an objection. They are not filing an appeal.
yes,
Why are
that's
you
true.
worried?
That is the, my lord, 1973, my lord, there is a
Say,
notification.
why are you
That is
worried,
true.
sir? They are also parties to the proceedings.
That is true. That is the
Then-
only ground, my lord.
Ah,
Yeah. But today that copy will be served, my lord, will also carry it. And fifth, my lord, in the order itself, my lord, will, in the order list only, my lord, let it be, my lord. On fifth, my lord, because this is the conversion order, my lord, deputy commissioner is, my lord, pass the order. On the ground that, my lord, it is.
Passed, it is passed after the
The-
period has lapsed.
Yes, that is.
Yes.
Only ground is, my lord,
Yeah, we can understand if the claim is that it's a government property, it cannot be converted. That is not so. You are saying it's a work property and work board is not contesting the matter.
that is true, my lord. Even they also filed or not. my
There
lord,
has to
that
be
is
some
also-
reasonableness, sir.
Our file ಮಾಡಿದ್ರಲ್ಲ, we are not the aware of that one, my lord.
ಬಿಡಿ, no.
Fifth ಇಟ್ಕೊಂಡು problem.
Even if that is there, my lord, such
ಅಲ್ಲ,
endorsement.
you will also record, my lord, submission and, my lord, you also have it on fifth,
Aitha, no.
because, my lord, this is conversion matter, my
Connected
lord, all
matter,
the
my
matters
lord,
has- there
after
is a-
considering, my lord, similar endorsement issued by the state government. My lord, this court, my lord, in writ appeal number 200007, last date of hearing, my lord, I had passed on, my lord, the order. 200007, my lord. Para number 7.
Nowhere in the RTC, the name of the work board is there reflected.
Since past 4 decades, my lord, it is signing in our name.
The name of work board
Never,
is not
never.
even, not reflected even in column number 11.
No, my lord.
No.
No.
Then. how
And
can
my
you
lord,
say it's a work property?
interestingly, my lord, one more hissa number 6, measuring 10 guntas is being converted by the very same deputy commissioner, my lord, which is also a part as an annexure in the writ petition. Same survey number, one more hissa is already been converted. Now, my lord, we are the institution facing severe difficulties because of my lord, this issue being, my lord, stuck. Para 6 onwards, my lord, this court has considered in detail whether, my lord, such endorsement could be issued, and then, my lord,
Para?
para 6 in writ appeal number 200007,
Hmm.
where similar endorsement was issued after 2 years. On reject last 4
6
lines,
of-
man,
Para 6 of what?
this judgment. There also I had preferred, my lord, contempt, and the state had preferred a writ appeal. Para 6,
Same grounds,
same grounds, same grounds.
But ಏನ್ರಿ, what is your deputy commissioner doing?
And in
Huh?
this,
But because of page number 53, my lord, for a moment. Annexure G. This is the remarks, my lord, on the basis
Now
of
we
this.
have,
remarks.
we have to start dismissing your appeals with exemplary costs.
So my lord.
ಅವಾಗ ಅರ್ಥ ಆಗುತ್ತೆ ನಿಮಗೆ.
Because only that.
Regular appeals are already dismissed. You want to file the same type of appeals again?
I'll get that for instruction. Put it.
ಕೊಟ್ಟಿನಲ್ಲ, copy ಕೊಟ್ಟು.
We find it.
ನಿಮ್ದೇನೆ
ತಾವೇ appear ಆಗಿ-
ಸ್ಟೇಟ್
ತಾವೇ appear ಆಗಿ-
ನೀವೇ ಇದ್ದೀರಾ?
Not subject matter of this land, my lord.
Same, sir, same type.
Issue is same.
Issue is same.
Is that- Whether I have to check it up, not whether it is filed the SLP or not.
SLP no dismiss ಆಗಿದೆ.
ನನಗೆ ಅರ್ಥ
SLP
ಆಗಲ್ಲ.
was
It is
preferred by the
notified.
state was dismissed.
I'll make it. my lord.
ಏನಾದ್ರೂ ಅದ್ರಲ್ಲಿ ತಿರುಳಿದ್ರೆ
ಹೌದು,
SLP ಫೈಲ್ ಮಾಡಿದೀವಿ ಅದು ಇದು ಅಂತ ಹೇಳ್ಬೋದು. This is the type of contention and it has been negatived. Where is the question if you filing SLP?
ಹಾಕಿದ್ದಾರೆ, dismiss ಆಗಿದೆ.
ಅಲ್ಲ, ಹಂಗ್ ಮಾಡಿದ್ರೆ you have to start dismissing your appeals with exemplary cost. Only then you will understand.
ಅದೇ ಒಂದು judgment ಮಾಡಿ ಸ್ವಾಮಿ.
Just because
ಸಹ್ಯದಲ್ಲಿ-
you are a state and you have the money power, You say, no, I will file an SLP. There should be some reason for that.
Reasonable ground has to be. I do understand well for the. I am
Same
handicapped.
grounds, they are saying, your contention, property belongs to the Waqf board. Waqf board is not challenging these orders at all. Barkali.
Fifth, my lord, your lords.
No. Writ appeal.
This is the my lord, instruction by the my lord, additional advocate general, my lord. But that is the reason, my lord, I am requesting. Vijay Kumar has to appear, my lord. Today's.
Probably he has not been instructed that these are
That's
the.
why, my lord.
This
You
is
also
the
corrected
background.
fifth, my lord, I will get the instruction, my lord. I will not argue the matter, my lord, or then I will make the submission. What
Learned
has happened, my
counsel
lord?
for the complainant in the contempt petition and the respondent in the appeal filed at the hands of the state submits that similar contentions were raised on behalf of the deputy commissioner, Bidar, and similar appeal, writ appeal filed by the state in WA number 200007 of 2022 has been dismissed by this court by order dated 10th of November 2022. SLP now ಹೋಗಿದ್ಯಾ?
ಆಗೋಗಿದೆ. Dismiss.
Thereafter, SLP preferred by the state in civil special leave petition bracket civil diary number 53315 of 2023 was also dismissed by the Honorable Apex Court on 14/5/2024. Full stop. Next para. We find that the contention of the Deputy Commissioner for rejection of the application for conversion is that the property belongs to the Waqf board. Full stop. It is surprising to note that despite such orders being passed, the Waqf board has not challenged the orders. And on the other hand, appeals and SLPs are being filed at the hands of the Deputy Commissioner, who seeks to contend that the property belongs to the Waqf board. Full stop. Nevertheless, despite such orders being passed, again, similar appeals are being filed at the instance of the Deputy Commissioner. Full stop. Next para. At this juncture, when we are about to dismiss the appeal, learned government advocate seeks for a short accommodation to secure instructions and make submissions. Full stop. Release this matter on 5th of November. Yes.
Okay. Great.
Serial number 19, Ravi B. Patil.
To 21. 21. Similar matters, my lord, up to 21.
20, 21.
Please.
18, 19,
21.
20, 21.
Please.
Yes.
Lord, in 20 and 21, they have not even issued endorsement. Serial number 20 and 21, at least he had an opportunity to have that endorsement and get it, although it is covered in the same writ appeal and the SLP order. But at least they have not even issued an endorsement, nor they have issued the conversion order. Yet they file my lord writ appeal.
See, we are doing this mistake. ಈ ತರದ ಕೇಸ್ಗಳಲ್ಲಿ unless we dismiss them with exemplary cause, they will not realize the mistakes that they are doing. We will do it. In this matter, they will do it. Yes.
Serial number 22, Ramachandran K. Serial number 22.
In this matter, my lord, we comply the my lord direction of the Salam Court, my lord. So issuing the endorsement.
Liberty may be given to the.
To challenge the endorsement.
Yes.
Kodi.
File, already filed.
Filed, huh?
Please.
Last date of hearing they have provided.
19/10/2024.
Please,
Huh?
please. 22/10/2024.
Already, that endorsement is dated
Yes, please, ma'am,
19/10/2024,
please.
annexure R8.
Yes, ma'am.
An affidavit of complaints has been filed on behalf of the respondent, Tahsildar Grade 1, Kamalapura Taluk, Kalaburagi district, along with copy of endorsement dated 19/10/2024, issued by the Assistant Commissioner, Kalaburagi Subdivision. Stop. Next paragraph. Learned counsel for the complainant submits that liberty should be reserved to the complainant to raise a challenge to the endorsement. Full stop. Next paragraph. Accordingly, the contempt petition is dropped having regard to the endorsement issued by the respondents to the complainant. Full stop.
Please.
At the same time, liberty is also reserved to the complainant to raise a challenge to the endorsement dated 19/10/2024. Yes, ordered accordingly.
CL number 23, AM Nagraj.
It's appearing for the appellant. Office has raised, my lord, objection regarding my lord, annexure D and E.
Oh,
Annexure D and E are the voters list of the, my lord, 3,000 odd voters. Some of the lines in the last page, my lord, there is not legible. That is the office objection. It's matter pertains to, my lord, the ineligible voters are, my lord,
Office objection is overruled.
yes,
Yes.
must have filed the special leave application since the appellants are not a party. It may be taken up along with IA tomorrow. IAs are not read. Or else, my lord, may permit to. This is a case, my lord, where ineligible voters are before the court to challenge calendar of events. Election is set in motion. They are, my lord, they may seek for participation in the election, my lord. Learned single judge, my lord, after filing a nomination of these appellants, my lords, who are not party to the proceeding.
Election to
Let's respondent number 9 bank.
primary cooperative society.
Yes.
Huh?
Yes. These appellants are, my lord, may I request, my lord, date of events, my lord? Election to the 9th respondent bank notified on 12/8, 12/8/2024, my lord. And nomination last date for filing nomination is 23/8/2024. This writ petition date of election was fixed on 31/8/2024. Writ petition was filed on 19/8 after, my lord, conclusion of, my lord, nomination papers. Last date is 23rd. On 22nd, 2024, this writ petition is allowed. 3 days, my lord. Within 3 days, my lord, writ petition came to be allowed and directed to redo the entire process. These appellants were, my lord, if the nominations were filed by these appellants, at the, my lord, only scrutiny is left. And the learned single judge has directed, may I request, my lord, order passed by the learned single judge.
Yes.
Page number.
What is wrong in the order?
No, it's court is directed with the respondent 9 is violated rule 13D, my lord.
Yes.
No, it's once calendar of events issued and elections are set in motion, my lord. Worst situation, my lord, the court can pass an order of, my lord, permitting the appellants, respondents here in, my lord, to participate in the
What
election.
was the ground on which the writ petition was filed?
Writ petition was filed on, my lord, the violation of 13D, my lord, where notices were not issued to the
13D
of cooperative societies rules. That was extracted in the order itself.
Yes.
Operative portion, my lord, may I request?
Procedure that has not been followed as such. The petitioners have been terminated to participate in the democratic process of running the society
In fact, the apex court has held that, my lord, the writ petition itself is not
The
maintainable.
chief executive officer of any cooperative society has to send a notice to the ineligible members
Yes,
15 days prior to 6 months
yes,
of the date of election, giving an opportunity. They have been declared ineligible members.
yes, ineligible
They have a
voters,
grievance.
they have a grievance, my lord.
Then
This, my lord,
you don't want to see what is the difficulty faced by them. They have been kept out of the election itself.
It is a
You
matter
want to
of,
take advantage
it
of
is a
that.
matter of, my lord, election.
Agadilla.
May I request, my lord, may
Agadilla.
judgment of the apex court.
No, anyway, we'll issue notice.
Your
that's all.
lordship has, my lord, in the
We'll
Bangalore.
issue notice, nothing more.
Your lordship has, my lord, passed an order before the Bangalore bench, where, my lord, your lordship has directed the, my lord, the petitioner therein to participate in the election, my lord, not to stall the calendar of once is set, calendar of events.
Advocate takes notice
1 to 8,
for response number
1 to 8.
ಇಲ್ಲ 1, 2.
ಕೆಳಗಿನ court-
Election
Election
1 to
officer.
3. The state cooperative election authority ನೀವು ಅಪೇರ್ ಆಗ್ತೀರೇನ್ರಿ?
Election officer of the cooperative joint registry.
Single judge ಅಲ್ಲಿ, my lord, 1 to 8, the government has taken notice. Page number 29.
Election commission ಇದ್ರೆ ಮಾತ್ರ ಬರಲ್ಲ ಸ್ವಾಮಿ. Returning officer.
1 to 8. No one appeared for respond number 9.
9, my lord, Mr. Amresh Roja has appeared.
Learned counsel Shri Amresh
Roja.
Roja
Yes.
is requested to take notice for respond number 9.
Lords, I will serve the copy on R9, R10
Issue notice to all the other respondents.
I may be.
So, the appellants are also permitted to serve copy of the appeal memo along with annexures on learned counsel Shri
Mantesh Patil. So,
Antesh Patil,
page 28.
who appeared for the writ petitioners. Full stop. Release this matter. A learned counsel for the appellant is directed to serve copy of the appeal memo along with annexures on the learned government advocate as well as learned counsel Shri Amresh Roja.
And Mantesh.
Mantesh Patil illೇ ಇದಾರೆ ನೋಡಿ ಕೊಟ್ಬಿಡಿ ಅವರು.
Yes.
Release this matter on 7th of November.
Instead of 7th, my lord, next week of after 7th. La notice.
11th or 12th?
12th.
12th.
Seal number 24, Chidege Kailash C.
Lord, being agreed by the order passed by the KST, this writ petition is filed, my lord. That this petitioner and her sons have filed a suit for declaration before the declaration of ownership of land, house, and the service benefits of her deceased husband who died while he was in service. Against the respond number 1 to 7 and 8. The Honorable Senior Civil Judge Bhalke was pleased to grant a TA restraining the respond number 1 to 7 for not to release 50% of the service benefits to the respond number 8. The respond number 8 appeared before the Bhalke court and filed objection. After hearing, the application was allowed. Meanwhile, the respond number directly appeared before the KST and filed this the application, wherein the Honorable survey KAT order was passed to consider both the applications in page number 100 and 101, my lord. ಇಬ್ಬರಿಗೂ ಕನ್ಸಿಡರ್ ಮಾಡ್ರಿ ಅಂತ ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ.
Seeking appointment on compassionate ground.
Yes, my lord.
Only that aspect of the matter has been
ಇಲ್ಲ ನಮ್ದು
question
ನಾವು my lord
before
ನಾವು
it is not about the property or the disbursement of the retirement benefits. ಅದಲ್ಲ.
ಇಲ್ಲ
Only in respect of appointment on compassionate grounds. That
ಅದರಲ್ಲಿ
is the only prayer made before the tribunal.
yes, my lord.
Because
ಅದರಲ್ಲಿ
that prayer could not have been made before the civil court.
ಇಲ್ಲ ಅದ್ರ ಸಲುವಾಗಿ ನಾವೇನನ್ನೋದು ಇಬ್ಬರದು ಕನ್ಸಿಡರ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಒಬ್ಬರಿಗೆ ಇವರು ಅಲ್ಲಿ ಇದು ಇಬ್ರು ಅಪ್ಲಿಕೇಶನ್
if there are rival claimants, the law itself says all the applications have to be considered jointly together. What is wrong in the order?
ಇಬ್ರು ಅಪ್ಲಿಕೇಶನ್ ಅಂತ ಸಿವಿಲ್ ಇದು ಸಿವಿಲ್ ಕೋರ್ಟ್ ನಲ್ಲಿ ಕೇಸ್ ಪೆಂಡಿಂಗ್ ಇದ್ದಾಗ
Civil court,
Right.
though, it is only in respect of the rights to share the,
share the property and
this is not about that. This is only regarding compassionate appointment.
I do agree, my lord. But it is that the
Nothing wrong in the
right
order.
of the parties has to be considered. ಈ ಸಿವಿಲ್ ಕೋರ್ಟ್ ನಲ್ಲಿ ಈ who is the first person and who is legally entitled ಅಂತ.
Takes notice for response number 1 to 7.
Please.
Issue notice to response number 8 to 10. Learned counsel
in-
for the petitioner is directed to serve copy of the petition along with annexures on the learned government.
My lord, interim application. My lord.
Yes,
Seal number 25, Mantesh Patil.
Submission is in each page of the judgment, my lords, backside. There is no road seal forthcoming from the certified copy secured from the trial court notes. Therefore, we made a submission that
still in,
how
it's not for,
in the backside of the
copy
page.
subjection is overruled. Yes,
Lords, this is the death case wherein the legal heirs of deceased person, we have filed the seeking compensation before the tribunal.
the SBI general insurance,
Subhash Mallapur and
learned counsel Shri Subhash Mallapur, who is present in the court, takes notice for respond number 3. Learned counsel for the appellant is directed to serve copy of the appeal memo along with annexures on learned counsel for respond number 3. Mele issue notice,
1 and 2 months.
issue notice to response number 1 and
Hearing on again, seal number 26, Eva M. Chimkod.
2 weeks time, my lord. R3, my lord.
Hmm?
2 weeks time, my lord. R3 and connected matters ಇದೆ, my lord.
for early hearing.
ಹೌದು, ಅವ್ರು ಹಾಕಿದ್ದಾರೆ, my lord.
Paper book ಹಾಕಿಲ್ಲ ಇನ್ನು.
Okay, sir. 2 weeks time may be done.
2 weeks time.
Paper book ಹಾಕ್ಬೇಕಮ್ಮ, ಆಮೇಲೆ ತಾನೇ ನಿಮ್ಗೆ early hearing.
Early hearing application was filed.
Respondent 1235.
Huh?
Respondents file at the hearing application.
ನೀವ್ ಹಾಕಿದಿರಾ?
Yes.
When was the direction issued? ಎರಡು ವಾರ ಸಾಕಾ?
ಸಾಕು.
2 weeks are granted at the request of learned counsel for the appellant to submit paper
ಒಂದು
books.
ಡೇಟ್ ಮೇಲೆ ಕೈಲಿ ಬಿಟ್ಟು
3 weeks.
3 ವಾರ ಕೊಡಿ ಸರ್, ಐ ಹ್ಯಾವ್ ನೋ ಅಬ್ಜೆಕ್ಷನ್, ಬಟ್ ಡೇಟ್ ಮೇಲೆ ಕೈಲಿ ಬಿಟ್ಟು ಪ್ಲೀಸ್, ಅದರ್ವೈಸ್ ದಿ ಪರ್ಪಸ್ ಆಫ್ ದಿ ಸೂಟ್ ವಿಲ್ ಬಿ ವಿಷೇಡ್.
Why? Partition suit.
Okay, my lord. This case is covered by Vinita Sharma. And the mother is depriving, old age mother, who is residing in
List
the
this, list
house
these
of
matters
21
for final
with the
hearing.
daughters.
On 19th of November.
Please.
God bless.
Yes.
Seal number 27, Siddharama Reddy Venkanna Pareddy.
Waiting for respondent.
Delay is there. Matter is called out. There is no representation for the appellant. Release this matter on 6th of November.
Seal number 28, Ravi B. Patil.
Two applications which are pending, my lord.
Huh?
Two applications filed by the appellant, my lord, which are pending. One application for appointment of rescuer that may not be, my lord, necessary at present stage, because, my lord, now, my lord,
For permission to amend the plaint.
how? Because, my lord, one of the business, my lord,
Incorporate additional pleadings.
but a proposed amendment to the prayer. There was one a business which was established during the lifetime of my deceased husband. Supplying generators to the LIC corporation, which was generating 1 lakh rupees per month.
This matter had come up last week.
How?
Huh.
Even before the direction could have been issued by this court, I had filed 2 applications. One is for appointment of the receiver for collecting the rent and towards the repayment of the loan awarded. Now that may not survive because the corporation has already deposited the money.
Already, we had recorded on the last time.
How?
The submissions made on behalf of respondent number 4, LIC.
How?
That they have issued notice for termination of the contract itself.
That they are entitled to.
That is why we had asked you to secure instructions and make submissions.
How? Now they want to terminate the license permission itself. Now, this business is being run by my brother-in-law. He has taken benefit for more than 6 years. Now, this relief.
Therefore, if they terminate the contract now.
Yes.
All that the court is required to consider is the benefit derived.
Yes.
Till the contract was in existence.
Yes. Therefore, that receiver appointment may not survive for consideration. Adanna close Swami. Insofar as amendment may not, because there is no prayer.
Having regard to the contents of the daily order dated 21/10/2024, where this court has recorded this submission made on behalf of respondent number 4, that the said respondent has issued notice of termination of contract, learned counsel for the appellant submits IA number 2 of 2024. May not require consideration, and the same can be disposed of. Stop. Next para. Accordingly, IA number 2 of 2024 stands disposed of. Yes.
IA 1 only to incorporate prayer with regard to the benefits accrued of this business.
That cannot be done in the absence of the other side.
They are not. No, all of them are served.
Otherwise, we can hear it along with the main matter. IA number 1 of 2024 will be heard along with the main matter.
Some date may. She is a widow, suffering a lot. Only house where she is
This matter for final hearing. On paper books ಹಾಕಿದಿರೇನ್ರಿ?
ಹಾಕಿಲ್ಲ ಹಾಕಿಸ್ತೀನಿ. ಹಾಕಿಲ್ಲ.
ಮತ್ತೆ
I will file within 2 weeks.
And we can't say admit also today because it's not coming up for admission. It is not coming up for admission, and other side is not here. 2 weeks are granted to the appellant to furnish paper books. Yes.
Seal number 29, Subhas Mallapur.
Look at challenging the order of KAT minutes. Next year, 7 to for the Kannada documents, dispense. Against KAT order, the Lokayukta has filed the appeal. Petition minutes. Annexure A1, A4 are the annexures of the application. They are in Kannada members. They are legible there. Posted for preliminary hearing.
Office objections are overruled. Notice order ಆಗಿದೆ ಆಗಲೇ?
ಆಗಿದೆ. Posted for preliminary hearing.
I have to take notice.
Government advocate takes notice for respondent number 2. Preliminary hearing ಬಂದು ಹೋಗಿದೆ.
Caveat was,
Any interim prayer? No interim prayer.
here the inquiry, entrustment of inquiry and the articles of charge have been.
First, learned
set aside.
counsel Shri Mahesh Patil
Yes.
has entered appearance for respondent number 1.
Yes.
Learned government advocate is directed to take note. Learned counsel for the petitioner is directed to serve copy of the appeal memo of writ petition along with annexures on the learned government advocate. Nimku bandidiyalla copy. Yes.
C number
Yes.
30 Vikram Vijay Kumar.
Matter is called out. There is no representation for the appellant. List this matter after 2 weeks.
C number 31 Vishal Pratap Singh.
Matter is called out. There is no representation for the appellant. Release this matter. On 8th of November.
C number 32 Bapugoda Siddhappa.
For the appellant claimant's appeal for seeking enhancement notice to the respondent number 1 may be dispensed notice.
Huh?
Notice to the respondent number 1 may be dispensed notice. If the second respondent is the branch manager IPCO Tokyo General Insurance Company, they already satisfied the award amount.
They are satisfied.
Yes.
The
matter may be referred to local development. Direct to take notice to the respondent number 2, the IPCO Tokyo General. It is a case of death notice.
Learned counsel Shri Sudarshan M is requested to take notice for respondent number 2.
No, notice.
You will get respondent 1 dispensation.
Yes, sir. I filed the dispensation memo.
Learned counsel for the appellant is directed to serve a copy of the appeal memo along with annexures on learned counsel for respondent number 2. Next para. Learned counsel has filed a memo seeking dispensation of notice to respondent number 1 on the ground that respondent number 1 is the owner of the vehicle and the liability has been fastened on respondent number 2. Full stop. At the risk of the appellant's notice to respondent number 1 is dispensed with. Full stop. Next para. Matter stands referred to local.
There is delay of 3 days in filing the appeal. Delay may be condoned. Delay of 3 days.
Of 3 days in filing the appeal is condoned. IA1 of 2024 is accordingly disposed of. Matter stands referred to local.
Local.
Number 33 Bapugoda Siddhappa.
This is also notice the R1 will be dispensed notice. The second respondent is the Manjunath Malay Shetty for ICICI Lombard General Insurance Company.
Accept notice, Maladi Sabha.
Same order. Manjunath
Malay Shetty.
Malay Shetty for
R2 months.
R2. Dispensation of notice to respondent number 1.
Delay is 88 days months.
Delay condoned. Matter referred to
Local.
Yes.
Preliminary matter C number 34 Nitesh Padial.
I appear with the petitioner.
Yes.
Petitioner was appointed as a graduate literate assistant, my lord, in the year 1978, my lord. Thereafter, my lord, in the year 1990, the service of the petitioner was regularized. And in the year 2004, my lord, the petitioner was given the representation, my lord, seeking for a corresponding pay scale to FDA, my lord. He is working as an literate equivalent to the post of the petitioner, my lord, equivalent to FDA.
Advocate takes notice for all the respondents. Learned counsel for petitioner is directed to serve copy of the petition along with annexures on the learned government.
Obliged.
C number 36 Ramachandra K.
My lord, we have challenged the single judge order dated 13/9/2024, my lord, for setting aside and quash the impugned order passed by the respondent number 3 and 4, my lord, as per annexure Q and R, my lord.
What is that order? What is that order?
Recall the construction permission given by themselves, my lord, on the basis of a false complaint lodged by the anonymous complaint, my lord. One Mukinder, who is third party, gave a consent to the said plot, my lord. He filed complaint before the corporation. On the basis of the false complaint, the construction permission given by them recalled, my lord, without hearing the petitioner. Therefore, the said order has been challenged before the single judge, my lord, which is not considered by the single judge, given the directions to municipal administrator to demolish the constructed building of the petitioner on 30th October, my lord, tomorrow, my lord. Therefore, we have challenged the single judge order here, my lord. If any illegal construction made by the petitioner, my lord, there is a provision of Corporation Act under section 112, my lord. They can impose penalty, my lord. Without hearing petitioner, they directly recall the construction permission given by them and
Sir, you should be fair in your submissions. Whatever has been noticed by the learned single judge, you will have to state it very clearly. What is the use of simply saying something which is not considered here? Is this the ground on which the petition is dismissed? Huh?
Complaints.
It was found that you filed an application on 8/7/2023 and the same was rejected on 25/7/2023 on the ground that you have already put up construction.
But the same engineer already, the earlier same engineer rejected my application, my lord.
Yes.
The again same engineer after spot panchinama, the given construction permission, my lord. There is no fault of petitioner, my lord. The same engineer once rejected again.
He said doing has been made by one Sri Shantanu Mulge, junior engineer.
The same engineer only rejected earlier, my lord. Again, the same engineer given construction permission, my lord. After E-Kata, my lord. Earlier, the.
See, if you have already put up construction, where is the question of giving you permission for putting up construction?
Prior to permission, if petitioner constructed the building, my lord, there is a provision under Karnataka Municipal Corporation Act that they can impose penalty, my lord. Straight away, they cannot order for recall the construction
then
permission.
What kind of an application should you file?
For seeking construction permission, my lord.
Huh?
Seeking construction permission, my lord.
Law provision, both. What is Municipal Corporations Act?
Under section 112, my lord. C. Page number 99, my lord. Section 112 C, my lord.
Yes.
Levy of penalty on unlawful building, my lord.
Yes.
Whoever unlawfully constructed or reconstructs any building or part of building
Without obtaining permission.
Yes, my lord. On his land without obtaining permission under this act or in contravention of any
shall be liable to pay every year a penalty which shall be equal to twice the property tax leviable on such building, so long as it remains as unlawful construction without prejudice to any proceedings which may be instituted against him in respect of such unlawful construction.
Yes. They can impose penalty, my lord.
That you want to rely upon.
Straight away without hearing petitioner, my lord, directly they recall the construction permission given by them, my lord. That is our grievance. They can impose penalty, my lord.
Where is the provision?
So here only the stating that.
For filing an application for regularization. And if you admit that you have already put up construction, where is the question of you filing an application seeking permission for construction of a building?
My lord, after I agree, my lord. After a rejection of my first application, I deposited.
Action will have to be directed to take against that junior engineer. I think that is what has been done now.
both side defect is there.
Huh?
Both side engineer also earlier rejected and
Provision illide, sir. You please point out now. Which is the provision?
only I'm saying that the penalty can impose by them, my lord,
Houdu.
under section 12, my
That
lord.
is regarding property tax. And it also very
No,
clearly
unlawful
says,
construction of the building, my lord.
please read it, sir. If it is there, you please read it.
C only, my lord, the on his land without obtaining the permission under this act, in contravention of any condition attached to the such permission or on site belonging to him, which is formed without approval under the relevant law.
Clause 1 apply agutte nimge.
Yes, my lord.
You have put up construction without obtaining a sanction plan.
Yes.
Shall be liable to pay every year a penalty. Nanu odudnalla iga.
Yes.
Where is the provision which would enable you to file an application seeking regularization? Then all this is clandestinely done.
My lord, however, he is not encroached any other's property, government property, my lord. He is constructed in his own plot, my lord. He deposited huge amount of 93,000 for construction of the building, my lord. He is ready to pay.
Unauthorized building now. You can't try to get it regularized by filing an application as if you are putting up new construction. That is not correct.
But he is ready to pay penalty, my lord. The
penalty you have to pay, that is for payment of property tax. The provision is put in place to ensure that people like you who have put up unauthorized construction will not enjoy the benefit of the building without paying penalty. Double the time of property tax you will have to pay. Adu penalty. That is what is considered in 112C. It does not say anything about regularization. In fact, it gives the scope that the commissioner is entitled to proceed in accordance with law. But notwithstanding the said, you are liable to pay twice the property tax. That is a penalty. It talks only of the property tax, really, not about regularization.
But observation made by the learned single judge is that we suppressed the matter, my lord, but we never suppressed the matter. Same engineer only they reject my application earlier on the ground that sorry, my lord.
How did you do it second time?
No. Both side, respondent side also.
All of us can understand how it is done. Learned government advocate takes notice for respondent number 1. Learned counsel Shri Kripasagar Patil is requested to take notice for the other respondents. Learned counsel for the appellant is directed to serve copies of the appeal memo along with annexures on the learned government advocate as well as learned counsel Shri Kripasagar Patil. Release this matter on 11th of November.
But there is directions to demolish the building, my lord. Status quo order, at least.
First opportunity is given to you to demolish yourself. If you don't do it, they will do it. Yes.
Seal number 37, Ulyappa,
Not, for petition, yesterday's matter.
For the respondent.
Huh?
For the respondent, kindly pass over.
Pass over.
Lord, may I have it on Monday, my lord. I have other matters in other courts.
ಬೇಕಾದಷ್ಟು ಟೈಮ್ ಇದೆ ರೀ ಇವತ್ತು ಮಾಡ್ರಿ.
Pass over. ಮಾಡಿ.
Seal number 38, Mahesh Patil.
Challenging not the order of the KT mode at page 121.
challenging the order of the KT, my lord, at page 121. My lord, it's a case of selection, my lord, wherein, my lord, I am the candidate for the selection, my lord, to school teacher, my lord, in a quota for, my lord, project displaced person. Even the fourth respondent is also a project displaced, my lord, person, my lord. Based on that, my lord, she had applied, my lord, and thereafter, my lord, her candidature was rejected, my lord, by way of endorsement, my lord, at annexure 8. My lord, on the ground, my lord, that she is not residing, my lord, with her father, and my lord, on the ground, my lord, her candidature was rejected, my lord, by the authorities. And my lord, I'm the next in line for, my lord, the appointment for, my lord, under the PDP, my lord, scheme. My lord, it was rejected, my lord, on the ground, my lord, that though she is a married, my lord, woman, and my lord, that she is residing with her, my lord, husband, and my lord, that there is a specific, my lord, clause in the notification saying as to, my lord, that the married daughters, my lord, since, my lord, that provision still remains. The married daughters, my lord, they should not apply, my lord, when they are, my lord, under the PDP, which is at annexure 8. Now, KT, my lord, has allowed, my lord, her application.
There is no doubt that your father was the project displaced person.
Yes, ma'am.
So the contention is that since you are already married, you are not entitled for the benefit.
My lord, I am the, my lord, now her application is allowed. Now, my lord, I am next in line for, my lord, I'm the next candidate in PDP. My lord, now her application is allowed. And my lord, I am challenging, my lord, the order of the tribunal, my lord, wherein, my lord, she has
Her application, the applicant's application was rejected on that ground.
rejected, my lord, and the KT has, my lord, allowed her application.
Correct. That person has a better merit than you.
Yes, my lord. Yes.
So what is your submission?
My lord,
What is wrong in the order?
My lord, it is, my lord, since, my lord, the notification, my lord, provides, my lord, for, my lord, the married daughters, my lord, they should not apply under the PDP, my lord, quota, my lord, of their, my lord, the father. And now, my lord, she is residing, my lord, with her husband.
Where does it provide?
My lord, it has been specifically, my lord, an endorsement is given, which is at page, my lord, 75, annexure 8. 75, annexure 8. ಮೇಲ್ಕಾಣಿಸಿದ ವಿಷಯ ಹಾಗೂ ಉಲ್ಲೇಖಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ 2021-22ನೇ ಸಾಲಿನ 6ರಿಂದ 10ನೇ ತರಗತಿ ಪದವೀಧರ ಪ್ರಾಥಮಿಕ ಶಾಲಾ ಸಹ ಶಿಕ್ಷಕರು ನೇಮಕಾತಿ ಸಂಬಂಧ 1-2 ತಾತ್ಕಾಲಿಕ ಆಯ್ಕೆ ಪಟ್ಟಿಯನ್ನು ಪ್ರಕಟಿಸಿದ್ದು, ಅದರಂತೆ ಸದರಿ ಪ್ರಕಟಣೆಯಲ್ಲಿರುವ ಅಭ್ಯರ್ಥಿಗಳ ಮೂಲ ದಾಖಲಾತಿಗಳನ್ನು ಉಲ್ಲೇಖಿತ 1ರಂತೆ ಇಲಾಖೆಯು ನಿಗದಿಪಡಿಸಿದ ದಿನಾಂಕಗಳನ್ನು ಪರಿಶೀಲನೆ ಮಾಡಲಾಗಿರುತ್ತದೆ. ಮುಂದುವರೆದು ಉಲ್ಲೇಖಿತ 2ರಂತೆ ವಿವಾಹಿತ ಮಹಿಳಾ
reading the endorsement given by them.
Yes, ma'am.
We are asking you which is the clause.
Yes, ma'am. Yes, yes.
I am sure it will not say anything. See, they have extracted the definition of project displaced person
Yes,
that we can see in page number 135.
oh, yes, madam.
Yes.
KCS general recruitment rules.
Members of the family to members of the family in relation to project displaced person means the family of the project displaced person consisting of such person of his or her spouse, sons, unmarried daughters. This is what you are harping on,
Yes, madam.
isn't it?
Yes, madam.
Now, the judgment is based on a decision of the Supreme Court.
Yes, madam.
Kumari Rekha Bharati, page number 141.
Yes, madam.
No distinction can be drawn between a married daughter and unmarried daughter for the purpose of considering the eligibility as per the guidelines. This is the law laid down by the Honorable Supreme Court.
Yes, madam. But
Yes.
here, my lord, the rules, my lord, have not been amended, my lord, thereafter. My lord, that is the only contention, my lord. The rules have not been amended.
Yes.
And my lord, based on this judgment, my lord, these applications, there are other applications, my lord, which are also allowed, my lord, which were jointly, my lord, taken up.
Other provisions are also found in the general recruitment rules of the state.
Yes,
And if you remember, there was one judgment passed by His Lordship Justice Nagaprasanna in respect of the said provision, which is a general provision which is applicable for all recruitments in the state.
Unmarried daughters should be read.
So immediately after that, the rules were amended. That order was passed even when this kind of a provision was there.
Yes, madam.
That order has been upheld.
I'm not thereafter, I'm not aware, my lord, whether these general recruitment rules, my lord, were amended.
Learned government advocate takes notice for response number 1 to 3. Issue notice to respond number 4. Learned counsel for the petitioner is directed to serve copies of the writ petition along with annexures on the learned government advocate. Yes.
Seal number 39, Ulyappa Yeru.
Lord, the petitioner, Lord. This petitioner has been suspended on one reason or the other. Lord will peruse annexure A1, the first suspension order, law, at page number 35. Annexure A1. This has been stayed by the KAT as per annexure A2, page number 43. Followed by, Lord, the application has been allowed as per annexure A3, dated 12th July. The suspension has been, order has been set aside. Again, once again, on as per annexure A4, Lord will see, again, once again, the petitioner has been suspended on 15/4/2024. This order has been challenged before KAT. KAT has directed to make a representation, one after another. I request my lord to straight away invite my lord's attention to annexure A10, page number 84. Suspended, removed, set aside. I straight away invite my lord's attention to annexure A10, page number 84. Once again, the applicant approached KAT at Bangalore. It was stayed. Thereafter, my lord, application came to be disposed of. Based on that, annexure A11, I have been given charge to function as DDPI. A11, page number 88. Thereafter, annexure A12 came to be passed. Once again, annexure A13, page number 116. Petitioner approached the Honorable High Court at Bangalore, where my lord is, were a part of the bench. Annexure A13, page number 116. Status quo is ordered. Despite of that, my lord, once again, I am suspended as per annexure A14. Just they are bent upon to shift me from that place for the reasons best known to them to bring their candidate. Annexure A4 is A14 is challenged in KAT as per annexure A. That the Honorable KAT has declined to interfere. Annexure B, page number 126. Agreed by that time before my law.
Your contention was you did not make any recommendation
My lord,
as a part of the 3-member committee.
yes,
You did not make any
No,
recommendation
I'm not a party.
for release of funds to the NGO.
Yes. Only proposals come to me after BO certification. And I'm not a party to that. The allegation that I have a guaranteed fund to private aided institutions. Absolutely, I'm not a that. And that has been already settled by the Honorable High Court's order. And at one point, my lord, annexure A13, 116 page, there is a stay by the principal bench. Still, they are suspending. Despite of that.
But you had filed the application earlier
Yes.
and it was rejected.
Yes, withdrawn. Application filed, application rejected.
Permitting you to raise the
Yes,
same
yes,
grounds
yes,
before
yes,
the inquiry
yes,
officer.
Yes,
Ah,
all that has been settled.
ಆಮೇಲೆ
Now, once again, A14 issued suspending me. Despite of that, there is a status quo order by the Honorable Principal Bench. My lord, annexure A13, page 116, my lord, were part of the bench. Annexure, my lord, A116, kindly peruse. Operative portion at annexure 117, my lordship were on the bench, part of the bench in this writ petition.
yes. The tribunal passed the order on 12th of July
Kindly
2024.
peruse page number 129. Page number 129.
Ah,
In the second paragraph, tribunal makes an observation that accordingly we hold that the applicant has not made out a prima facie case for granting stay.
No, what happened after this order was passed by the tribunal at page number 61? You were directed to be reinstated.
Yes,
ಆಮೇಲೆ
reinstated, reinstated, again suspended,
Huh?
again suspended.
Again suspended.
Yes, annexure A14, my lord will peruse page number, annexure A14 at page number 119. As per annexure A11, I am reinstated, page number 88. Annexure A14 ಅಲ್ಲಿ ಮತ್ತೆ suspend ಮಾಡ್ತಾರೆ ನನಗೆ. Despite of the stay order being there in the from the principal bench, honorable principal bench.
Reinstatement ಆಯ್ತಾ
ಆಯ್ತು, annexure A1 ಬನ್ನಿ ದಯವಿಟ್ಟು, page number 88, annexure A11. May I read, my lord? ಸರ್ಕಾರದ ಆದೇಶಗಳಿಗೆ ತಡೆಯಾಜ್ಞೆ ನೀಡಿರುವ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಶ್ರೀ ಸೋಂಡ್ಸೋ ಅಮಾನತಲ್ಲಿರುವ ಇವರನ್ನು ಉಪನಿರ್ದೇಶಿಸೋ ಈ ಹುದ್ದೆಯಲ್ಲಿಯೇ ಮಾನ್ಯ ಉಪನಿರ್ದೇಶಿಸೋಣ ಇದೇ ಹುದ್ದೆಯಲ್ಲಿಯೇ ಮಾನ್ಯ ನ್ಯಾಯಾಲಯದ ಆ ತಡೆಯಾಜ್ಞೆಯನ್ನು ತೆರವುಗೊಳಿಸುವವರೆಗೆ ಮುಂದುವರಿಸಿ ಆದೇಶ. ಅಲ್ಲಿಂದ ಮತ್ತೆ A14 ಸಸ್ಪೆಂಡ್ ಮಾಡಿ
2024.
Yes. Again A14, my lord, this is.
So again you approached the tribunal.
Yes.
In page number 89.
Yes, my lord.
ಏನಾಯ್ತು ಈ ಸರಿ?
This, my lord, page number 89, this application has been dismissed. Annexure A12. This application has been dismissed. Once again they suspend me. I approach the KT. After KT, again I approach principal bench. Principal bench grants me status quo on 25/9/24, page number 117.
Principal bench ಏನ ಹೇಳಿದ್ರು ನೀವೆಲ್ಲ ಈಗ?
Status quo ಆಗಿದೆ.
In respect of
Yes,
other.
yes. And once again they suspend me on 14/10, page number 119, next year A14. Stay order ಇದ್ದಾಗಲೂ ನನಗೆ ಸಸ್ಪೆಂಡ್ ಮಾಡ್ತಾರೆ.
Page 95. This is in respect of which order?
This is not against some other order, suspension and dismissal. That is different issue. This stay order is against another suspension order, not this.
Yeah, ಏನೇನು suspension order
ಅವರು
ಮಾಡ್ತಾರೆ
they
ನಿಮ್ಮ ಮೇಲೆ?
wanted to shift me and bring their candidate. They want to bring their own candidate by shifting me right from annexure A1, my lord will see. Suspending and again once again
This order has already been passed by the division bench at the principal bench.
Honorable principal
Why
bench.
did you approach the principal bench?
Against the another order of KT.
Another order?
KT, suffering order of the KT.
Which order?
My lord, that order is dated 25/9/24, where I have withdrawn the application.
ಅದೇನ್ರಿ ಕೆಲವು ಅಲ್ಲಿ ಚಾಲೆಂಜ್ ಮಾಡ್ತೀರಾ, ಕೆಲವು ಇಲ್ಲಿ ಚಾಲೆಂಜ್ ಮಾಡ್ತೀರಾ?
Jurisdiction.
How?
Jurisdiction. Principal bench. My lord, principal bench based on the jurisdiction applicant. This is Vijaypura. He is DDP Vijaypura now. So he has approached this gate.
You are the person who was also approached the principal bench.
Same person.
ಅಲ್ಲಿ jurisdiction ಏನಾಗುತ್ತೆ?
ಅಲ್ಲಿ government authorities orders. Authorities orders.
All these are authorities only.
Yes.
Then?
Yes.
How can you pick and choose?
No, I'm sorry.
Go on filing petitions here. You file
sorry.
petitions before the principal bench.
I'm sorry.
Huh?
I'm sorry. because I am not there before the principal bench.
But you are showing the order passed by the principal bench.
Agreeing, my lord, the party is same, authorities are same. I am, it is in my favor. That is why I am submitting. Order passed by the honorable principal bench is in my favor.
But we are not able to understand, sir, by on which order you went before the principal bench?
25/9/24, kindly,
ಎಲ್ಲಿದೆ ಅದು?
kindly page 117, order annexure A20 dated 35/24. My lord will see annexure A8, page number 79.
Suspension.
Yes.
Order of suspension dated 15/4/2024.
Yes, yes. This is the order dated. My lord will find it annexure page number
And
79.
now why have you come before this bench?
Withdrawn. That application has been withdrawn and filed once again before KIT Bangalore. Withdrawn. Approached Honorable High Court. Honorable High Court granted me status quo against that order. Now, number of suspension orders are passed against me only to with a view to remove me from that place. That is only my grievance. Now, if when there is a status quo in my favor, where is the question of my lord passing once again annexure A14, suspending me for an irrelevant charges? 101, my lord will see page number 109, annexure A14.
Order was passed by the principal bench on 21st of September 2024.
Yes.
ಅದಾದ್ಮೇಲೆ ಮತ್ತೆ ಇನ್ನೊಂದು
ಮತ್ತೆ ಮಾಡಿದ್ದಾರೆ ನೋಡಿ, ದಯವಿಟ್ಟು ಪೇಜ್ ನಾವು 1 to 3 ಬನ್ನಿ.
1, 2, 3.
The operative portion of the order. Annexure A14. Operative portion is already 1, 2, 3.
14,
Dated 14/10. ಮತ್ತೆ ಮಾಡಿದ್ದಾರೆ ನನಗೆ. ಅದನ್ನ, that is my grievance.
ಏನ್ರಿ ಇದು? What is this?
Earlier, my lord, application was dismissed, my lord, not followed the rule, my lord, 10.3. Not followed the, my lord, rule 10.3 and that was the, my lord, dismissed by the our suspension order.
The first order
Yes,
that we saw at the tribunal.
Yes. Thereafter,
ಅದಾದ್ಮೇಲೆ reinstate ಮಾಡಿದ್ರು.
this is the order, my lord, which is, my lord, that writ petition number 25800, which is the subject matter, and that is not forthcoming. 30/5/2024 and that.
And when there is an order passed by the principal bench directing you to maintain status quo, how did you pass one more order?
But he given the application, my lord,
21st
for
of
restoration.
September, under 21/9/2024. Again 14/10 another order is passed.
Page number 81, my lord, for me. Page number 81. ಮನವಿಗಳನ್ನು ಮಾಡಿ, that there was already suspension order, my lord. Thereafter, my lord, he given the representation to reinstate by withdrawing their suspension order. So that was rejected. That is, my lord, page number 81. So that is challenged before the, my lord, principal bench. Status quo is directed. ಮನವಿಗಳನ್ನು ಖಂಡಿಸಿ ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ವಿವರಿಸಿದ ಹಿನ್ನೆಲೆಗಳಲ್ಲಿ ಮಾನ್ಯ ಕರ್ನಾಟಕ ರಾಜ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ರಿಟ್
ಇದು ನಿಮ್ಮ ಸಿನಾಪ್ಸಿಸ್ ಲಿಸ್ಟ್ ಆಫ್ ಕ್ರಾನಾಲಜಿಕಲ್ ಇವೆಂಟ್ಸ್ ಅಲ್ಲಿ have you stated ಏನಿಲ್ಲ, ಬರೀ ಎರಡು ಹಾಕಿದ್ದೀರಾ ಅಷ್ಟೇ.
That is a confusion.
ನೀವು ಕ್ರಾನಾಲಜಿಕಲ್ ಆರ್ಡರ್ ಅಲ್ಲಿ ಎಲ್ಲ ಹಾಕಿದ್ರೆ ಈ ಕೂಡ ಏನು ಇಲ್ಲ.
Now matter is, my lord, posted on
Suspension orders, my lord. Kindly.
8/11/2024.
How can you go on passing orders
This is
after
the-
orders like this?
That is, my lord,
Orders of suspension. What was found? That he has clearly stated that I have not passed any order, nor my committee has passed any order directing release of the funds.
please.
So this was not considered anta, that was the finding. Therefore, that order was passed, directing him to be reinstated. Accordingly, he was reinstated.
Please. Thereafter,
if you have to pass an order of suspension, should you not show the reasons? What is the reason?
But that is why, my lord, his stay was not considered by the tribunal. then it is posted on 8/11. But your lordship directed the tribunal to ascertain all the aspect and even the principal bench stay order also. Then directed the tribunal to pass the order on 8/11. 8/11 date is fixed. Even let him file all the chronological, all the documents.
In the order of suspension, what information is available that made you to reissue the order of suspension? Ali, there was a finding. See, he has taken the stand that neither me nor my committee has passed any order directing release of the funds.
Please.
What prima facie material have you found now?
That is 121 dalli ella idu kottidare. 121.
Please point out.
Please. But he only approved without any, that is the serial number 2, page number 121 17 ಶಾಲಾ ಆಡಳಿತ ಮಂಡಳಿಗಳು ಆಕ್ಷೇಪಣೆಗಳನ್ನು ನಿಗದಿಪಡಿಸಿದ ಕಾಲಮಿತಿಯಲ್ಲಿ ಸರಿಪಡಿಸಿ ಸಲ್ಲಿಸಿದ ಯಥಾ ಅರ್ಜಿಗಳನ್ನು ಉಪನಿರ್ದೇಶಕರು ಲಾಗಿನ್ಗೆ ಮರು ಸಲ್ಲಿಕೆಯಾಗದಿದ್ದರೂ ಸಹ ಅವುಗಳಲ್ಲಿ 6 ಪ್ರಕರಣಗಳು ಆಕ್ಷೇಪಣೆಗೆ ಪೂರಕ ದಾಖಲೆಗಳು ಇಲ್ಲದಿದ್ದರೂ ಉಪನಿರ್ದೇಶಕರು ನಿಯಮಾನುಸಾರ ಅನುಮೋದಿಸಿರ್ತಾರೆ. Not only obtaining the approval from the board, but he is also approved himself.
Yes.
No, my only.
Come to page number 121.
Yes, ma'am.
Now they have furnished the reasons.
Yes.
While passing this order of suspension.
Yes.
They have given all these reasons, particularly in respect of you.
Yes.
Please see this.
This, my lord, if they had issued a letter, I would have replied. And on top of it, my lord, principal bench has stayed my suspension order.
It is pointed out that order of maintaining status quo is passed in respect of your representation, that it was rejected.
No,
on that one, you have gone before the principal bench. Principal bench has directed maintain status quo. This is not regarding that. This is regarding order of suspension. So now, when we compare to what was earlier found in the order of the tribunal, that though you have taken the stand, that I have not passed any order as a member of the committee for releasing of the said amount, and that aspect of the matter was not considered, has not been looked into. There was no prima facie material available to show that you have signed the order directing them to release the funds. Now they have given each and every aspect of the matter where your decision has been found, which is not in accordance with law.
If a notice is issued or letter is, I would have replied instead of suspending.
No.
Instead of suspending.
Not at that juncture, sir. No. If the authority is satisfied that there is prima facie material available, then it can pass an order of suspension. So our question to them was, what is the prima facie material available? They are pointing out to page number 121.
Suspension orders one after another. Several suspension orders are passed, and there are certain suspension orders are quashed. And like this, if a letter is given to me, I would have replied to it.
ಅದು ಮುಂಚಿಂದು ಸಸ್ಪೆನ್ಷನ್ ಆರ್ಡರ್ ಕಾಪಿ ಅಲ್ರಿ?
Please.
Where is that? (15/4/2024) page number 63.
Yes. This is the suspension.
So only there is no such details given.
Yes.
That was why fault was found. Now in page number 121, they have given all the details.
That is the observation by the tribunal also in the import order.
Which is
Page number 128.
Oh, you have come on interim order.
Interim order.
declined to grant interim.
Yes.
They have not made out any case on prima facie case.
For the tribunal. ಎಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ?
Page number 129.
128.
There be 129.
Para 2. We have produced the records.
Have considered the requirements of rule 10(1)B while shifting the lien of the applicant. Respondent authorities are directed the applicant to hand over charge Srimati Uma Devi, who is facing similar charge.
She has been directed to be handed over the charge.
We are directed to give the, directed us to assign to another person charge, my lord. That is, my lord, 129. my
When
lord.
was that order passed?
This is passed down, my lord,
2210.
2210.
2210.
And that Uma Devi, my lord, has been issued with the show cause notice.
Yes, that was, we are also, my lord.
ಅವ್ರ ಮೇಲೆ ಆಕ್ಷನ್ ತಗೋತಾರೆ, ಅವ್ರನ್ನು ಸಸ್ಪೆಂಡ್ ಮಾಡ್ತಾರೆ. But that is not going to help you.
ಬಗ್ಗೆ ಇಲ್ಲಿ ಚಾರ್ಜ್ ಕೊಡಿ ಅಂತ ಹೇಳ್ತಾರೆ.
No. That is why the tribunal has also directed that to
Another
take note of that and take action accordingly. That is not going to help you. We'll only issue notice ಅಷ್ಟೇ, ಏನು ಮಾಡಕ್ಕಾಗಲ್ಲ ಇದು. Learned government advocate takes notice for
Response 1 to 3.
response number 1 to 3. Issue notice to respond number 4. Learned counsel for petitioner is directed to serve copies of the writ petition along with annexures on the learned government advocate. Full stop. Next para. Learned government advocate is directed to secure instructions as to the action taken consequent to the observations made by the Karnataka State Administrative Tribunal in the impugned order dated 22/10/2024 regarding charge being handed over to Srimati Uma Devi, who is also facing similar charges. Next para. Release this matter. On 6th of November.
Interim order, my lord. At least status quo, my lord.
ಇಲ್ಲ, there is already a direction. ಅವ್ರ ಮೇಲೂ action ತಗೊಳ್ಳಿ, see that she is not put in charge. That is why we are directed to secure instructions and make submission. Yes.
List number 2, CL number 1, preliminary matter, Prakash Jadhav.
This is the matter, my lord, how writ petition is maintainable against the order of the enquiry officer.
ಎಲ್ಲಿ ಅವರು?
ಬೆಳಿಗ್ಗೆ ಏನೋ ಟೈಮ್ ಕೇಳ್ಬೇಕಂತ ಏನೋ ಬಂದ್ರು.
ಕೊಡಿ, ಆ ಸರ್ಕ್ಯುಲರ್ ಕೊಡ್ರಿ. ಸಿಂಗಲ್ ಜಡ್ಜ್ ಮುಂದೆ ಹೋಗ್ಬೇಕು. ಸರ್ಕ್ಯುಲರ್ ಪ್ರಕಾರ CAT matters will come before the division and set in the circular. Therefore, where similar other occasions may arise in any proceedings, an order or judgment of the Honorable Single Judge of this court, whether sitting or retired, functioning in any other authority, is questioned before the Honorable High Court in writ petition invoking jurisdictions under Article 226, 227 of the Constitution of India shall be posted before division bench. Alli, if an order is passed by a retired judge, illi there are no orders passed. Register. So therefore, it had to go before the learned singles. Purple. On the previous occasion, we had pointed out that prima facie this writ petition should have been placed before the learned single judge. Yes?
Yes, nothing, Lord.
Correct, Tane?
Oh, sir.
Single judge munde hogbeku. Full stop. However, since office had not raised any objection, and since on an earlier occasion, similar writ petition were entertained before the division bench. In writ petition number 200768 of 2023, we are directed the office to place before the court the relevant circular.
My lord, relevant circular also.
We have it. Stop. Next para. Today, the circular dated 13th of August 2002 is placed before the court. Full stop. We find that having regard to the judgment of the Honorable Supreme Court in the case of L. Chandrakumar versus Union of India, it was directed that judgments rendered by the Karnataka State Administrative Tribunal or the Central Administrative Tribunal will have to be placed before the division bench. Wherever challenged should be placed before the division bench. Full stop. However, it is also provided in the circular that wherever similar other occasions would arise, where orders passed by a judge of this court, whether sitting or retired, when challenged under writ jurisdiction under Article 226 and 227 of the Constitution of India, such matters should also be placed before the division bench of this court. Full stop. Next para. However, in the present case, there are no orders which are challenged having been passed either by the Lokayukta or the Upalokayukta. Full stop. What is under challenge in this writ petition is
Annexure G and H. Annexure G and H. The government issued the order dated 13/2/2023.
Government order dated
13/2/23
and charge memo.
Yes, my lord. Issued by
the registrar.
Yes, my lord.
Of the Lokayukta.
Full
stop. Therefore, this matter is required to be placed before the learned single judge. Full stop. Next para. The concerned, including the concerned officers in the scrutiny section, and more particularly the learned registrar judicial, is hereby directed to ensure that there is strict compliance of the circular dated 13th of August 2002. Full stop. It should be ensured that if any order not passed by a retired judge of this court
single judge and retired judge.
sitting there. By a learned single judge, whether sitting or retired, is not the subject matter of the writ petition, then such matters should be placed before learned single judges and not before the division bench. Full stop. Next para. List this matter before the learned single judge. Yes.
Much of it.
Admission matters, CL number 40, Ramachandra K.
Yes.
My lord, we have challenged impugned order passed by the family court in MC number 119 of 15, only on assumption and presumption, my lord. The appellant and respondents are the married couples, my lord. The respondent deliberately without any cause approached before the family court and filed the petition under section 11 of Hindu Marriage Act seeking decree of nullity of the marriage of the marriage with the appellant, my lord. On the ground that appellant was already married with one Ashwant and had 4 children, my lord. The court below, without looking to the facts and circumstances.
4 children.
Yes, ma'am. There is no documentary evidence produced by the respondent before the trial court to prove his case, my lord. Only assumption and presumption, the judgment has been passed by the family court. The respondent filed quoting wrong section also.
Admission bartarada. Notice has been issued.
Yes, appeared, my lord.
There is appearance for the respondent.
Yes, Abhiraj B.
Again, it is coming up for admission. Huh? The trial court records are to be secured.
Please.
Bandidiya?
Not it.
Bandilla.
Call for it.
Admit. Call for trial court records.
Please.
Serial number 41, G. Chakshetty.
Appearing for the appellant, my lordship. In this, the appellant filed a petition under section 13(1)B for dissolution of marriage, my lordship. That family court which approved decreed.
First, why is it coming up for admission? Huh?
My lordship. No, notice is already served, my lordship.
Huh?
They are appearing on behalf of respondent, my lordship.
So, trial court records bandide. You are ready? Huh?
Yes.
Really?
My lordship, the petitioner herein filed a petition under section 13(1)B(5) of Hindu Marriage Act, my lordship, for dissolution of marriage.
Petition has been dismissed.
No, my lordship. It has been granted, my lordship.
Petitioner appellant.
I am for the appellant. Only in respect of
Appellant was the respondent.
my lordship, only in respect of a permanent annuity, I am before this.
Appellant
under the
has
court, my
filed
lordship.
petition before family court Vijaypura for granting divorce, my lord.
For dissolution of marriage.
Marriage.
It was granted, my lord.
Granted, my lordship.
Subject to that, the permanent alimony of rupees 10 lakh was granted
Granted
on
in-
the basis of the respondent in this case. She is suffering in HIV, my lord.
Positive, my lordship. She is
So
a
therefore, looking on the circumstances and facts of the case, and the appellant is having source of income by way of landed property and also having a Vinod Tours and Travels agency. On this ground, the permanent alimony of rupees 10 lakh was granted, my lord.
my lordship.
Thereafter, the appellant was deposited amount of rupees 2,50,000 before family court. It was drawn, my lord. So question remaining only 7,50,000 is to be
Paid.
paid by the appellant, my lord.
Even a
Since
single
from
documents before the
2009
trial-
Amount you already paid.
My lordship, only in respect of 2,500, I have already deposited subject to the result of interim order, my lordship.
2,50,000.
2,50,000. My lordship, the contention which has been taken that he is running a Vinod Travels, it has not been proved before the trial court, my lordship. He is having only 3 acres of dry land, my lordship. In spite of that, he must maintain his old age parents and some other family members, my lordship. It is a larger amount. So for decrease of some extent, I am before this honorable court, my lordship.
2011, the marriage took place.
But marriage took place in 2011.
The decree of dissolution has been passed on 30th of March 2019.
P19.
Yes, my lordship. Yes, my lordship. In
Then
spite,
whose
all-
responsibility will it be?
my lordship,
Is it not your responsibility? Your responsibility, Amma. Just because that lady is suffering from HIV,
I agree, my
you
lordship.
should be on the roads, is it?
I'm not,
Then?
against that, the amount is a larger side, my lordship. It may be reduced and I am ready to give, I'm always ready to give the money, my lordship.
ಈಗಾಗಲೇ ಕೊಡ್ಬೇಕಾಗಿತ್ತು ನೀವು. ನಿಮ್ ಕೈಲಿ ಎಷ್ಟಾಗ್ತೈತೋ ಅಷ್ಟು ಕೊಡ್ಬೇಕಾಗಿತ್ತು.
I have already.
2,50,000 ಕೊಟ್ಬಿಟ್ಟು ಸುಮ್ನೆ ಆಗ್ಬಿಟ್ರಿ.
No, my lordship. It
Then?
may be disposed of by reducing some extent, my lordship, because 10 lakhs is a higher side, my lordship. Even I am not, they say that I am the owner of a tour travels, my lordship. In spite, they have not produced single documents. Unfortunately, the travel name and my name is same, my lordship. I am owning, I am a taxi driver. Arrangement of 10 lakh is very higher side, my lordship.
ಏನಮ್ಮ ಯಾರು who's going to take care of her now? Is it the responsibility of her parents?
No, my lordship.
ಮತ್ತೆ?
In spite of all the marriage expenses was borne by me, my lordship.
ಅದೆಲ್ಲ ಬಿಟ್ಬಿಡಿ,
And I have
ಅದೆಲ್ಲ
already given some of the gold, my
can't
lordship.
go into all those details now.
Ten.
ಏನ್ರಿ
ಸರ್
ಏನ್ ಹೇಳ್ತೀರಾ? For the submission of the learned counsel.
ಸರ್ ಆಕ್ಚುಲಿ ನಾ ಇನ್ನ ಅನೌನ್ಸ್ಮೆಂಟ್ ಕೇಳ್ಬೇಕಂತ ಮಾಡಿದ್ದೆ ಸರ್.
My lordship.
ಅಪ್ಲಿಕೇಶನ್ ಫೈಲ್ ಮಾಡಕಂತ ಮಾಡಿದ್ದೆ ಸರ್.
ಆಯ್ತಲ್ರಿ.
ಇಲ್ಲ, ಮಾಡಿಲ್ಲ, ಅದೇ ಸರ್.
2019.
ಇಲ್ಲ,
You are
correct
still
sir.
contemplating.
ಇಲ್ಲ ನಾ ಅವ್ರ ಅಪ್ಲಿಕೇಶನ್ ಫೈಲ್ ಮಾಡಿದ್ರೆ ನಾನ್ ಮಾಡಿಲ್ಲ ಸರ್. ಯಾಕೆ ಮಾಡಿಲ್ಲಪ್ಪ ಸರ್, ಅಮೌಂಟ್ 10 lakhs ಇದು ಕೊಟ್ಟು ಬರ್ತದ. ಸಪೋಸ್ ಈಗ 7.5 ಈಗ 7 ಕೊಡ್ಬೇಕು ಸರ್. 2019 ಹಿಡಿದು ಇಲ್ಲಿ ತನಕ ತೊಗೊಂಡ್ರು ಅಬೌಟ್ ಮೋರ್ ದೆನ್ 5 lakhs ಇಂಟ್ರೆಸ್ಟ್ ಬರ್ತದೆ ಸರ್. ಈಗ ಅದನ್ನು ತೊಗೊಂಡ್ರು ಬರೋಬ್ಬರ್ 7.5 ಬರೋಬ್ಬರ್ ಆಗ್ತದೆ. ನಾನೇನು ಹೆಚ್ಚಿನ ಬೇಡ ಸರ್. ಸಪೋಸ್ ಇದೆ ಸರ್, ಪೇಜ್ ನಂಬರ್ ಇಂಟರ್ನಲ್ ಪೇಜ್ ನಂಬರ್ 9 ಬಂದಿದೆ ಸರ್, ಕ್ಲಿಯರ್ ಕಟ್ ಇದೆ. Petitioner in his cross-examination admitted, sir. Petitioner in his cross-examination admitted that he is owning one taxi. His family is having 3 acres standard property and a house at Nandikeshwar village, Badami Talaka. He denied the suggestion that he is running the institution called Vinod Tours and Travels, but he deposed that he is working as a driver in Sensation. It is to be noted here that the name of petitioner is Vinod. Hence, it appears that the petitioner is running and said institution that is Vinod Tours and Travels.
Appears ಅಂತಂದ್ರೆ
Appears.
Hence, it appears.
My lordship, though
there is no cogent evidence.
ಮುಂದೆ ಬಂದಿದೆ ಸರ್, ಮುಂದೆ ಬಂದಿದೆ. He also own a landed property, village Badami, and hence.
First, in respect of the tours and travels, you have not placed any material.
Metal place. No.
Just because the name is similar, they have jumped into a conclusion. Yes, he is the owner of the agency ಅಂತ.
And he was, due to COVID,
Only a driver ಅಂತ ಹೇಳ್ತದಾನಲ್ಲ ಅವನು.
But they are not produced any driver ಅಂತ ಅವರು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ.
ಹೌದು, if it is a travel agency, then you could have got the information from the competent authority.
The amount which was granted by the family court is correct, my lord. There is no any.
ಒಂದ್ 2 ಲಕ್ಷ ಕಡಿಮೆ ಮಾಡ್ತೀವಮ್ಮ, ಅದಕ್ಕಿಂತ ಜಾಸ್ತಿ ಆಗೋದಿಲ್ಲ.
I live to this honorable.
ಇಲ್ಲ ಸರ್, ಕೇಳ್ಕೊಂಡು ಹೇಳ್ತೀನಿ ಸರ್. ಅವ್ರು ಒಲ್ಲ ಅಂತ
Maybe disposed of.
ಬೇಡ ಅಂತ ಅಂದಿಲ್ಲ.
ಒಳ್ಳೆ ಅಂತ ಹೇಳೋದಲ್ಲ, there is
ಇಲ್ಲ
no
ಸಾಕಷ್ಟು
material.
ಇಲ್ಲ ಸರ್, ಈ ಪಾಯಿಂಟ್ ರೇಸ್ ಆಗಿದೆ.
There is no material placed. There is no material placed. You can't jump into conclusion like that.
I will ascertain and close matter. ನಾ ಕೇಳ್ಕೊಂಡು
We will pass orders. We need not ask the party.
Sir,
It is only, if it is only this much,
correct, my
we
lord.
will consider the material available on record.
The 1.
Trial court records ಇದೆ.
ಸರ್ ಇದೆ
We will
ಬಂದಿದೆ.
go through that one and we will pass orders.
ಇದೆ ಸರ್, ರೆಕಾರ್ಡ್ಸ್ ಇದೆ.
ಅದೇ ಇಲ್ಲಿದೆಯಲ್ಲ.
ನಾನು ನೋಡ್ಕೊಂಡು ಇದು
ಬಂದಿದೆ.
ಒನ್ ಟೈಮ್ ಕೊಡಿ ಸರ್. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಇಡ.
Only dragging on the.
ನನಗೇನಿಲ್ಲ ಸರ್, ನಾನೇ ಯಾರಿಗೂ ಇದು ಹಾರು ಮಾಡಲ್ಲ. ಅವ್ರಿಗೆ ಪಾಪ 9 ವರ್ಷದಿಂದ ಅಮೌಂಟ್ ಕೊಟ್ಟಿಲ್ಲ ಸರ್. ಇವನ್ ಇನ್ನೊಂದು ಅವ್ರ ಮಗಳಿದ್ದಾಳೆ ಸರ್, ಒಂದು ಮಗು ಇದೆ ಆಲ್ರೆಡಿ.
ನಾವು 2 ಲಕ್ಷ ಕಡಿಮೆ
ಒಂದು ಮಗು ಇದೆ ಸರ್.
ಇನ್ ಬಾಕಿದು ಎಷ್ಟು ದಿವಸದಲ್ಲಿ ಕೊಡ್ತೀರಾ?
ಇವ್ರದ್ದು ಇನ್ನೂ ಒಂದು ಮಗು ಇದೆ. ಇನ್ನೂ ಒಂದು ಮಗು ಇದೆ ಸರ್, ಇವ್ರ ಹತ್ರ ಇದೆ ಸರ್. ಒಂದು ಮಗು ಸಹಿತ ಇದೆ, ಅದನ್ನ ಸಹಿತ ತಗೊಂಡ್ರೆ ಮತ್ತೆ ನಾವು ಕಡಿಮೆ ಅನ್ನಕ್ಕಾಗುತ್ತೆ ಆಕ್ಚುಲಿ.
ಎಲ್ಲಿದೆ?
ಇಲ್ಲ ಇದ್ರಲ್ಲಿ ಇಲ್ಲ ಸರ್, ಮಗು ಇದೆ ಅಂತ ಬಂದಿರೋದು.
Nothing has been disclosed in this, my lordship.
But it is true that there is a child.
not
Yes,
aware, my
having one child.
I am not aware, my lordship. That is.
The parties before the court are directed to, we'll ask both the parties to appear,
Yes, madam.
huh?
Yes.
Are directed to appear before this court on the next date of hearing.
Yes.
Release this matter. ಯಾವಾಗ 7ನೇ ತಾರೀಕ ಆಗ್ಬೋದಾ? On 7th of November.
Yes.
Yes, please come.
C number 42, Liaquat Farid, Ustad.
For enhancement, my lord.
I have a respondent.
The accident is of year 2017, my lord. Tribunal has taken 8,000. As per chart, my lord, it has to be taken 10,250.
Trial court records ಇದೆಯಾ? ಹಾ? ಬಂದಿಲ್ಲ. ಬೇಕಾ ರೆಕಾರ್ಡ್ಸ್ ಬೇಕಾ?
ಬೇಕಾಗಿಲ್ಲ sir.
ಬೇಕಾಗಿಲ್ಲ.
Enhancement ಇದೆ.
ಎನ್ಹಾನ್ಸ್ಮೆಂಟ್ ಇದೆ. ಅದರಲ್ಲಿ ಇದು ಮಾಡಿದ್ರೆ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ನಾವು ಇಬ್ರು ಕೂಡ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಮಾಡಿದ್ವಿ ಸ್ವಾಮಿ.
ಇಂಜುರಿ ಕೇಸಾ ಡೆತ್ ಕೇಸಾ?
ಡೆತ್ ಕೇಸ್.
ಡೆತ್ ಕೇಸ್. ಹಾ.
Lord, before the tribunal, my lord, earning was considered 8,000. My lord, here of accident, my lord, 2017 is there. If it is, we are go for my lord, notional income, my lord.
Notional income.
Please. 10,250 is there.
ಕೊಡಿ ಅದು ಚಾರ್ಟ್ ಕೊಡಿ. One 4/2017.
Please.
10,250. ಎಷ್ಟು
plus.
ತಗೊಂಡಿದ್ದಾರೆ ಇಲ್ಲಿ?
My lord, 8,000 ತಗೊಂಡಿದ್ದಾರೆ.
8,000 ತಗೊಂಡಿದ್ದಾರೆ.
And plus 40%
Plus
future prospect.
40% future.
ವರ್ಕೌಟ್ ಮಾಡಿದೀರಾ?
Please.
Yes,
ಕೊಡಿ.
it will
ಅವ್ರಿಗೂ
come,
ಕೊಟ್ಟಿದ್ದೀರಾ ಕಾಪಿ?
it will come up to.
ನೋಡ್ರಿ ನೀವು ಇಲ್ಲಿಗೆ ಬನ್ರಿ, ಈ ಕಡೆಗೆ ಬನ್ರಿ. Please come. If
ಇಲ್ಲ,
both of you are on the same page, then we will pass orders.
Yes.
ನೋಡಿ ಅಲ್ಲಿ.
ಮಾಡಿದ್ವಿ 5,01,4080.
Date of accident 1/4/2017. It should have been 10,250. What is awarded is 8,000. Please.
Deductions ಎಷ್ಟು ಮಾಡಿದ್ದಾರೆ?
1/5.
1/5 ಮಾಡಿದ್ದಾರೆ.
Correct ಇದೆ.
ಇದು ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟಸ್
40%.
40%. Dependents.
7 members are.
7 members are. 2,80,000.
In so far concern, consortium.
Dependents. Dependents is
7 ಜನ.
7 ಜನ. Wife and children and parents.
7 ಜನ. ಅಂದ್ರೆ ಯಾರ್ಯಾರು?
My lord, wife, respond number 1, wife. And 2 to 5 childrens. 2 to 5, my lord, the childrens.
2 to 5.
Please. 6 and 7, my lord.
5 ಅಂದ್ರೆ 4 ಜನ. 4 ಜನ ಮಕ್ಕಳು.
ಹೌದು. 6 and 7 parents.
Parents.
Please.
So
ಅಲ್ಲಿ law and effect
1/5 deduction, my lord. 1/5 deduction. My lord, 10,250 plus 40% into 12 into 17. My lord, personal expense 1/5 deduction, my lord, 23,41,920.
ಅಲ್ರಿ ಇವಾಗ ಏನು ಇವಾಗ ಆ 3 ಹೆಡ್ ಅಲ್ಲೂ ಈಗ 40,000 ಈಚ.
So for consortium, my lord, 40,000, my lord, 40,000 each person.
ಅಲ್ಲ ವೈಫ್ ಈಸ್ ಆಲ್ ರೈಟ್.
Please.
4 ಜನ ಮಕ್ಕಳಿದ್ದಾರೆ.
ಹೌದು. But in so far concern already
not passed by the division bench. ನಾವು ಹಂಗ್ ಮಾಡಕ್ ಆಗೋದಿಲ್ಲ. ದೀಕ್ಷಿತ್ ಸಾಹೇಬ್ರು ಜಡ್ಜ್ಮೆಂಟ್ ಬರೆದಿದ್ದಾರೆ. ಇನ್ನೊಂದೆರಡು ಡಿವಿಷನ್ ಬೆಂಚ್ ಬರೆದಿದ್ದಾರೆ.
Lord, in so far convention letters, my lord, already awarded 1,70,000. Already convention letters awarded, my lord, 1,70,000. Lord, that is just and proper.
ಬೇರೆ ಮೇನ್ ಹೆಡ್ ಕಿನ್ನ ಇದೇ ಜಾಸ್ತಿ ಆಗೋದು.
ಹೌದು.
ಅದಕ್ಕೇನೆ ಇಟ್ ಕೆನಾಟ್ ಬಿ ಕನ್ಸಿಡರ್ಡ್ ಲೈಕ್ ದಟ್ ಅನ್ಬಿಟ್ಟು.
Please. Lord, already awarded 1,70,000 just and proper. My lord, insofar concerned loss of dependency, my lord, 23 lakh 41,920. Only loss of dependency.
Towards dependency and loss of future income.
Please. That is, my lord, 23 lakh 41,220. If it is minus, my lord, 18 lakh 27,840.
Come 5 lakh.
40.
ಇದೆ ಅದಾದ್ಮೇಲೆ ಈ ತರದ್ದು ಕೆಲವು ಸಿಚುವೇಶನ್ಗಳು ಬಂದ್ಮೇಲೆ ದೇರ್ ಇಸ್ ಎ ರೀಥಿಂಕ್. ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹೌದು, ಸುಪ್ರೀಂ ಕೋರ್ಟ್ದೇನೆ ಅದನ್ನ ಕ್ಲಾರಿಫೈ ಮಾಡ್ಕೊಂಡು ಕೆಲವು ಈಗಾಗಲೇ ಸುಮಾರು ಜಡ್ಜ್ಮೆಂಟ್ಸ್ಗಳು ಬಂದಿದ್ದಾವೆ. It cannot be looked at it from that angle. We'll have to consider if there are so many dependents, that will be the whatever you are giving on loss of towards love and affection, that will be more than the main ground on which the calculation should be done. ಕೆಲವು ಕೇಸಲ್ಲಿ 6 ಜನ 7 ಜನ.
Only 1 lakh.
That is why they said no, cannot be done like that. There is no restriction to get in our. ಅದಕ್ಕೇನೆ ಈ ಇಂಥ ಸಿಚುವೇಶನ್ it cannot be converted into a windfall. That is also the principles laid down by the Supreme Court. This is something that the courts are trying to see that the aggrieved family is able to go on in the same fashion as it was prior to the death of the bread earner. It cannot be converted into a windfall. Correct. ಇವಾಗ ಏನ್ ನೀವು ಯಾವ ತರ ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡಿದ್ರಿ?
Lord, 10,250.
30,000 ಅಲ್ಲ, ಇದ್ರದ್ದು ಏನ್ ಮಾಡಿದ್ರಿ ಇವಾಗ? ಅದೇ this is that what we are discussing now is something to be added. 1 lakh
Already, my lord, insofar.
Towards the widow, there is no difficulty.
Please.
Parents also there is no difficulty. The only difficulty is regarding the children. 4 of them are there.
1,70,000 ಮಾಡಿದಾರೆ sir.
1,40,000. Funeral expense of ಸೇರಿ ಬಿಟ್ರೆ
1 lakh towards love and affection.
ಹೌದು.
ಇದು ಕೆಳಗಡೆನು
70,000 ಕನ್ಸೋರ್ಟಿಯಂ ಮತ್ತೆ ಲಾಸ್ ಆಫ್ ಎಸ್ಟೇಟ್ ಫ್ಯೂನರಲ್ ಅಂತ
30-70 ಮಾಡೋದು.
ಹೌದು.
ಅಲ್ಲಿ 1,40,000 ಬರುತ್ತೆ.
ಹೌದು.
ಈಗ ನಾವು ಇದು ಕೊಟ್ರು 1,80,000 ಬರುತ್ತೆ. ಓನ್ಲಿ 40,000 is ಓನ್ಲಿ 40,000 ಮಾತ್ರ. 2 lakh 1,40,000 ಡಿಫರೆನ್ಸ್. 2,80,000 ಆಗುತ್ತೆ. ಇದಾದ್ರೆ ಕೊಟ್ರದ್ 1,40,000.
ಇದೆಷ್ಟಾಗತ್ರಿ ಇವಾಗ? ಟುವರ್ಡ್ಸ್ ಲಾಸ್ ಆಫ್ ಡಿಪೆಂಡೆನ್ಸಿ ಎಷ್ಟಾಗತ್ರಿ? ಇದಾ 23,41,920.
Please.
Instead of 18,27,840.
Please. Yes.
23,41,920 minus 18,27,840. ಎಷ್ಟಾಗತ್ರಿ?
Lord, 5,14,000.
5,14,000.
80 rupees.
80.
ಹೌದು. ಸೊ
ಇಲ್ಲಿ ಒಂದು 1,40,000 ಜಾಸ್ತಿ ಆಗುತ್ತೆ. ಇದ್ರ ಪ್ರಕಾರ ಕೊಟ್ರೆ 2,80,000 ಕೊಟ್ರೆ
7 ಜನ ಅದಾರ.
Yes, what is your submission?
My lord, my submission is that, my lord, so for conventional heirs, my lord, is already awarded, my lord, love and affection 1 lakh and my lord 70,000, 1,70,000 is there. That, my lord, that was just and proper.
That can be retained.
Only in so far loss of dependency, my lord, that may be.
Because of the amount taken, That is, yeah, only 8,000, it should have been at
10,250,
please. ಇದ್ರ ಬಗ್ಗೆ ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ. ಗೊತ್ತಾಯ್ತು, ಬಟ್ ಬರ್ದಿದಾರಲ್ಲ, ಕೋಆರ್ಡಿನೇಟ್ ಬೆಂಚಸ್ ಹ್ಯಾವ್ ಆಲ್ರೆಡಿ ರಿಟರ್ನ್ ಬರ್ದಿದ್ದಾರೆ. ಹೌದು, ಈಗಾಗಲೇ 3-4 ಬಂದಿದೆ ಆಗ್ಲೇ. ಒಂಥರ ಹ್ಮ್. $140,000 ಬರ್ದಿದಾರಲ್ಲ ಈಗಾಗ್ಲೇ. ನಮ್ ಕೋಆರ್ಡಿನೇಟ್ ಬೆಂಚಸ್ ಬರ್ದಿದಾರ ಆಗ್ಲೇ. I think 2 or 3 coordinate benches have already written. Unless that is set aside. Allala, they are satisfied with this one. There is no difficulty. ಈ ಹೆಡ್ ಅಲ್ಲಿ ಅವ್ರು ಕೊಟ್ಟಿರೋದು, there is no difficulty. They are accepting, yes, ತೊಂದ್ರೆ ಇಲ್ಲ ಅಂತ. ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ ಅವರು ಇಲ್ಲ, ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ they have not challenged because they are satisfied with whatever, and they also accept this. Yes, it should have the notional income should have been taken at 10,250. Reasons ಸುಮ್ಮನೆ ಒಂದು ಅಂದಾಜು 2019 April 2019 judgment in the 10% 3 years 10%. Magma judgment copy the really. ಏನ್ ಹೇಳ್ತೀರಾ ನೀವು? You have to give it in terms of magnum, you have to give it ಅಷ್ಟೇ.
But on submission, my lord, here Pranay Shetty judgment, my lord, full bench judgment is there. Pranay Shetty, my lord, on basis of my lord, Pranay Shetty awarded my lord 15,000 funeral expenses, loss of estate 15,000, and my lord consortium 40,000. Includes conveyancers, my lord, total awarded 70,000. On the basis thereafter, my lord,
It cannot exceed 70,000.
also. ಅದಾದ್ಮೇಲೆ ಇದು ಬಂದು
This Pranay Shetty was
full bench
tendered earlier or Magma?
ಇಲ್ಲ earlier is
Pranay Shetty is earlier.
earlier.
ಅದಾದ್ಮೇಲೆ
Magma ಬಂದು.
ಅದನ್ನ ಕನ್ಸಿಡರ್ ಮಾಡಿ ಮ್ಯಾಗ್ಮಾ ರೆಂಡರ್ ಮಾಡಿದ್ರೆ then we'll have to follow Magma.
But that was full bench judgment is there, but Magma.
See, the law having regard to Article 141 is that if the Supreme Court has passed any order subsequently, After considering the larger bench judgment,
That is also
it
referred.
would be binding.
ಇಲ್ಲ ಇಲ್ಲ ಲೋಕ ಅದಾಲತಲ್ಲಿ ಅದರ ಕಂಪ್ನಿ ಮೇಲೆ ಡಿಪೆಂಡ್ ಅಪ್ ಒಂದೊಂದು ಕಂಪ್ನಿ ಎಕ್ಸೆಪ್ಟ್ ಮಾಡ್ತಾರೆ ಸ್ವಾಮಿ, ಇಲ್ಲಾಂದ್ರೆ ಒಂದೊಂದು ಕಂಪ್ನಿ ಮಾಡ್ತಾ ಇಲ್ಲ. ಓನ್ಲಿ 70,000 ಅದೆರಡು ಸಲ ಏನಾರ ಇದು ಮಾಡಿ, ಯಾಕಂದ್ರೆ ಅಪ್ರೂವಲ್ ಸಿಗಲ್ಲ ಸ್ವಾಮಿ.
ಸೀಟಿಂಗ್ ಲೋಕ ಅದಾಲತ್ನಲ್ಲಿ ಇದ್ರ ಪ್ರಕಾರ ಕೊಟ್ಟಾರ ಮ್ಯಾಕ್ಡಮ್ ಕೇಸ್
ಅದು ಹಿಡಿದಿದ್ದಾರೆ ಸ್ವಾಮಿ.
One lakh 70 ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ ಈಗ. ಇಲ್ಲೇ 1,70,000 ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಈಗ
ಹೌದು.
3,10,000
ಇದ್ರ ಮೇಲೆ ಇನ್ನು 1,40,000 ಜಾಸ್ತಿ ಆಗುತ್ತೆ. ಹಾ ಆಯ್ತು ಮಾಡ್ಬಿಡಿ. ಆಲ್ ರೈಟ್.
ಆಯ್ತು. ಇರೋ 1 ವರ್ಷ 2 ವರ್ಷ ಇಯರ್
Bill number 43, Abdul Muqtadir.
Appearing for respondent 7 to 10 purchasers. Plaintiff's appeal song.
Yes.
The suit for the partition.
Admission.
For admission.
ಹಾ
Notice to the
RFA.
respondent 1 to has to be issued. 1 to 7. Notice has to be
You are
issued.
asking for a temporary injunction.
Yes,
ಏನಂತ?
not to alienate.
Not to alienate.
My lord,
During the pendency of the appeal, not to alienate.
my lord, one submission.
Ah.
In short point, the suit was dismissed on the ground of deficit court fee and delay in filing, my lord, limitation, my lord. And I have purchased in the year 2016.
Huh?
I have purchased the property in the year 2016. In 17, they collude and filed this suit for partition, my lord. Claiming to be tenants in common, my lord. In fact, claiming to be tenants in common.
Yes.
They are Mohammedans, my lord.
Yes.
And in fact, in the year 1968 itself, land tribunal has granted occupancy rights to the father of my vendor, my lord. That has not been challenged. And if my lord peruses in page number 40, 66 running page, issue number 5, the trial court has clearly held that
66.
Page number 66, para 50, my lord. May I read?
Yes.
So far as partition suits are concerned, the following article 110 of Limitation Act would apply, which is a general act applies to all. 110 is called out, and next, my lord, admittedly, father of plaintiff died on 23/10/97, and he was fully aware of the proceedings before the land tribunal Gulbarga when an order was passed in 19 December 1978. Whereas the suit was filed by plaintiff in the year 2017.
Father of plaintiff died on 23/10/1997. And he was fully aware of the proceedings before the land tribunal, Gulbarga. And an order was passed on 19/12/1978.
Yes.
ಏನಂತ?
Occupancy rights were granted in favor of this vendor, father of this vendor, my lord. Father of the respondent number 2 to 5, sir. Plaintiff.
Occupancy rights were granted to whom?
The Babu Mian. Babu Mian, the father of the respondent number 2 to 5.
Defendants before the trial court.
How is the plaintiff related to the defendants?
Paternal, Babu Mia is the paternal uncle of the plaintiff.
Paternal uncle.
Paternal uncle. The family tree is at page number 7. Sir.
So occupancy rights were not granted to your father.
No, sir. It was granted.
Granted to the father of the defendants.
Yes, sir. So our case was that one. There were other 3 property which has been jointly applied, which has been partitioned. This one was only allowed to be father of the defendant number 2 to 5 to be, he has applied for the benefit of the whole family. So that was our case. The court, trial court comes to conclusion that if we had been in possession or other thing, you would have challenged the long back, or you would have asked for the partition long back. Even for that reason, the court has come to a conclusion that the suit is also barred by limitation.
Yes.
So,
many items of property or only one item?
Only one land property. Items are partitioned for me. This only one item was not
After
partitioned.
I purchased in 2016, they filed in 2017. Para 51. The court holds that when form number 7 was filed in year 73-74 by Babu Mia by excluding other 2 brothers, and in the column of family of form number 7, he mentioned as self, wife, 5 sons and 2 daughters. Then and there only the cause of action arose to file the suit for partition. Further on 1912-1978, when the land tribunal granted occupancy rights exclusively in the name of Babu Mia alone, and also when suit property was excluded in 1998 during family partition, the cause of action arose. Therefore, court holds that defendant 8 to 10 proved that
family partition.
ಅದು ಬೇರೆ ಪ್ರಾಪರ್ಟಿ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ, ಇದು ಬಿಟ್ಟಿದ್ದಾರೆ.
ಯಾವಾಗ?
In the year 98, my lord.
The other suit survey number 33, 24 and 7.
So the court holds that defendant
1998.
Yes, my lord.
During family partition.
Yes.
98.
Yes. This is filed in 2017, man.
Family partition alli this property was not included.
Not included.
Yes.
So our case is this one, Swami, because it was
so on 2 occasions cause of action arose for you and your father.
Yes, sir.
One, when the order was passed by the tribunal. Second, when partition took place in the year 1998.
Yes, sir.
On both the occasions, there were no objections raised.
No, my lord.
In respect of this property.
The tribunal, it was went for the high court. They have challenged. Once again, it was remanded.
Yaar challenge madiddu?
The landlord of the property was challenged.
You did not raise a challenge. Andre, your father did not raise a challenge.
Yes, sir. My father, we were 3 brothers, and this one
ಅದಕ್ಕೆ ಹೇಳಿದ್ದು. On the second occasion, 1998, when there was a partition,
yes, sir,
and this property was not included. At that point of time also, your father did not raise an objection.
Because still the proceedings were
there was
pending,
a partition.
Proceedings were pending for me. Proceeding with
ಹಂಗಂತ ಹೇಳಿದಾರ partition suit ಅಲ್ಲಿ. I mean, if a registered partition deed is executed, have they said something about this property like that?
Nothing like
then
that.
My lord, para 54. Page number 42, para 54, madam. Maybe looked it.
Anyway, that is the main matter. Then if this kind of an order is not passed, then it will become infructuous if you further dispose of the property.
My lord, para 54 maybe looked it.
Houdri, if that is the only issue. And even though we are not satisfied, but having regard
on the basis of court fee as well as limitation on both points, it is dismissed.
The notice to be issued.
They are saying they continue to be in joint possession. So therefore, they have paid for court fee accordingly. If they are ousted.
Revenue basis for
Agricultural lands.
Agricultural land.
ಎಷ್ಟು ಬರುತ್ತೆ?
Agricultural land farm, it will come around 100 rupees.
The amount for which we have purchased is around 1 crore, my lord.
We will direct you not to alienate. Learned counsel, Naresh P. Kulkarni has entered appearance for response number 7 to 10. Who are the others? 1 to 3?
1 to 6, there's the
1 to 6.
1 to 6, one is uncle and others are my cousin brothers.
Issue notice to response number 1 to 6.
Yes, sir.
They have given you a copy of the appeal memo.
Yes.
Huh? Next para. Having regard to the fact that the claim of the appellant plaintiffs is that the suit schedule property is a joint family property. And this court is required to consider the correctness of the order passed by the trial court. In this regard, the respondents, Urena 7 to 10.
7 to 10 are the purchaser of the property. We are in position.
7 to 10.
7.
Respondents number 7 to 10 are directed not to further alienate the suit schedule property till the disposal of the appeal. Yes.
They have purchased through agreement of sale. Still the sale deed.
ಇನ್ನು ಸೇಲ್ ಆಗಿಲ್ವಾ?
ಇನ್ನ sale. ಇಲ್ಲ, sale deed ಮಾಡಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ.
Huh?
Subsequently they have executed sale deed.
ಆಗಿದೆಯಾ?
Yes. All right. Okay. Call for
Call for trial court records.
Serial number 42, there was delay of 767 days.
676
Delay condoned.
ಇಲ್ಲ ಅದು without already condoned
Condone ಆಗಿದ್ದು ಅದು
without interest condoned.
Without in the ಎಷ್ಟು
676 days.
ಅದನ್ನ ನೋಟ್ ಮಾಡ್ಕೊಂಡು ಎಸ್ ನೋಟ್ ಮಾಡ್ತೀವಿ ಅದ್ರಲ್ಲೇ ಬರ್ಕೊಂಡಿ ಅಲ್ಲ while condoning delay, it was already directed that the appellants will not be entitled for interest, please, during the delayed period. Order dated
1/7/2024.
For enhanced complaint.
Serial number 44, GG Chakshakti,
It's a complainant,
appearing, my lordship. It may be taken up next week.
Huh?
Next week, my lordship.
acquittal against appeal is there. It's a complainant.
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 Learned additional SPP. ಆಗಿದೆಯಾ? ನೋಟಿಸ್ ತಗೊಂಡಿದ್ದೀರಾ?
Notice ಆಗಿದೆ sir. Possible. ಆಗಿದೆ. Shivanand V. Patansheti has appeared for R2 mailers.
ಆಗಿದೆ.
ಆಗಿದೆ.
ಸರಿ ಮತ್ತೆ. You not filed any, your complainant.
Complainant.
Complaint.
The matters to be heard only after securing the trial court
Records.
records. ಅಷ್ಟೇ ತಾನೆ?
Records for.
State has not preferred.
No mailers. State has not.
Call for trial court records. Yes.
B with matters, serial number 45, Ravi B. Patil. Ravi B. Patil,
Matters called out. There is no representation for the petitioner. Release this matter on 12th of November.
serial number 46, Mahesh Patil,
In this matter, my lord, please directed us to give the posting, my lord, to the petitioner. We given the posting also, my lord, copy is also produced before lordship.
Yes, my lord. They have given the copy. my
He
lord.
has to go and
But,
join to the first that
I
post.
have joined the government also. Now, one submission I want to make, my lord, here, my lord, since from 5 months, my lord, though I was willing to work, my lord, no postings were given, my lord. My lord, let them, my lord, regularize, my lord, my this 5 months period. my lord.
First, let. him-
Regularize.
Yes, my lord, because, my lord, ನನ್ಗೆ ಏನ್ ಮಾಡಿದ್ರು, ಅದಾದ್ಮೇಲೆ, I was out of, my lord, once the stay was vacated, thereafter, my lord, they were required to, my lord, give postings to me. For about 5 months, my lord, I am without postings, and I was seeking, my lord, and there are, my lord, many a times, my lord, they took adjournment, my lord, only to give me postings. Now they have given me postings. My lord, now, my lord, those, my lord, the period, my lord, let them, my lord, regularize. My lord. Otherwise, my lord, they may treat it as LWA also. Since I was willing to, my lord, the order sheets, my lord, shows, my lord, that. my lord,
Even there is no
They-
posting,
they-
my lord, he has to report before the head office, my lord.
Hmm.
If he reported to the head office, my lord, that will be regularized. That is the.
No, no, my lord,
that will be
without,
taken as a-
my lord, without, my lord, they were, my lord, they were, my lord, continuously, my lord, seeking adjournments, my lord, to provide me postings. And my
No.
lord, only now, my lord, they have provided. It's been from months, my lord. Lordship may kindly see the order sheet also.
Yavdu, which order?
My lord, the court order sheet. no?
Huh. 10/4/2024, order of stay.
Yes, but thereafter it was vacated. It was vacated. Because I was, my lord, willing to work. My period, my lord, since, my lord, during the pendency, my lord, my period, my lord, over of 2 years.
Twenty-two four ಗೆ order pass ಮಾಡೋದು, vacating the earlier order.
Yes, ma'am.
The initial order was passed on 10/4.
Yes, ma'am.
It was vacated on 22/4.
Yes, ma'am.
It was there in operation only for 12 days.
Immediately, my lord,
Immediately at that point of time, you should have sought for direction.
yes, my lord, at that point of time, my lord, I gave up, my lord, on merits. And my lord, my lord, the court directed, my lord, to give me postings. Thereafter, my lord, the matter, my lord, came to be adjourned, my lord, on their request.
Huh?
Thereafter, my lord, repeatedly, my lord, the matter came to be, my lord, adjourned on their request, my lord, that on the guise of, my lord, that they want to give me postings. Now, my lord, I was willing to work. It's not that, my lord, I wanted to, my lord, argue on merits in this matter. And even, my lord,
You should have sought for a direction.
yes, my lord,
Such direction.
because, my lord, only, my lord, when they give me postings, my lord, I'll have to go to that place, my lord, and, my lord, I'll have to, my lord, seek.
And nothing further remained after this order vacating the interim order was passed.
Yes, my lord.
What remains in the writ petition? Nothing remained.
And nothing remained, my lord.
You should have gone and reported then.
My lord, ಎಲ್ಲಿ ನಾನು ಹೋಗ್ಬೇಕು ಅಂತ ಅನ್ನೋದು, my lord, it is unclear, my lord. Because, my lord, I was, my lord, even.
When this order of vacating was passed, you should have either sought for a direction at the hands of this court, asking them to give you a posting.
Yes, my lord, I had very much, my lord.
ಏನ್ ಬರ್ದಿಲ್ವಲ್ಲ ಇಲ್ಲಿ?
But ಅದ್ರಲ್ಲಿ ಇರ್ಲಿಕ್ಕಿಲ್ಲ, my lord. My learned friend knows. And, my lord, since from the day, my lord, when it was vacated, my lord, we gave up on merits, my lord. And, my lord, we only, my lord, were seeking postings. And only, my lord, they were yet to find me a place. My lord, the matter went on, my lord, to this day. And it's, my lord, nearly, my lord, 5 months now. And, my lord, otherwise, my lord, I'll have to, my lord, file another application for, my lord, regularization of this period, my lord. It will, my lord, again.
Yes, what do you say?
But now, my lord, we given the posting on 24th, my lord. He is not ready to go and join.
I joined the government, government join ಆಗಿದೆ.
Let him report it, my lord. It's not reporting. it,
ಆಯ್ತು
my lord.
ಬಿಡಿ. ಇನ್ಮೇಲಿಂದ ಹೋಗಿ ರಿಪೋರ್ಟ್ ಮಾಡ್ಕೊಳ್ಳಿಲ್ಲ ಅಂತಂದ್ರೆ he will suffer.
Yes, madam.
That's why.
We are now considering about the period between the order when this which was passed on 22/4 and
Let him
2024.
give the representation to the, my lord, this authority, my lord. In accordance with law, my lord, will consider it.
ಯಾಕಂದ್ರೆ if we were the learned judges who had passed this order
Please.
and we knew what has happened, transpired after that, we could have simply written it,
Yes.
saying that yes, we had issued directions to the learned government advocate to give a posting ಅಂತ ನಾವು ಬರಿಬೋದಾಗಿತ್ತು.
Yes. ಅದು ಬಂದಿಲ್ಲ ಅದು.
ಇಲ್ಲಿ ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಬರ್ದು ಇಲ್ಲ ಅದೆಲ್ಲ.
That is a problem.
ಬರ್ಕೊಳ್ಳಿ. The petitioner had filed this writ petition assailing the order passed by the Karnataka State Administrative Tribunal in application number 20878 of 2023, dated 4th of April 2024. Stop. That was an application filed by the petitioner. Who was aggrieved, on being aggrieved of his transfer from ಎಲ್ಲಿಂದ ಎಲ್ಲಿಗೆ?
From Hunaski, B Gudi to Hunaski.
A3.
Narayanpura Left Canal Division, KBJNL Unsigi to
No, my lord, from
Bhimrayangudi
Bhimrayangudi, my lord,
Gudi, Shahpur Taluk.
Bhimrayangudi, Shahpur Taluk
to Hunaski.
Krishna
Hunsigi.
Bhagya Jala Nigama, Nemata Unsigi, Surpur Taluk.
ಆಯ್ತಾ? ಇದು ಎಷ್ಟು the distance between the two places?
My lord, around 40 kilometers.
It was observed by the tribunal that the distance between the two places is less than 40 kilometers. Full stop. Having regard to the observations made by this court in the case of R.D. Ramadas versus the state of Karnataka and others in writ petition number 11934 of 2022, that the transfer guidelines were framed only to prevent arbitrary exercise of power or by turning transfers into a tool of harassment or to mitigate any personal hardship that may be suffered by parties. And it was not meant to question transfers which were made within the district and the place of postings were not far away from each other. Full stop. The tribunal therefore held that since both the applicant and fourth respondent have been transferred within the district and within short distance with prior approval of the Honorable Chief Minister with reasons, the application cannot be sustained. Full stop. Accordingly, the application was dismissed. Full stop. Nevertheless, when the petitioner approached this court and sought for interim directions, this court, by order dated 10/4/2024, stayed the impugned order, subject to the condition that respondent number 4 has not taken charge as on the date of the order. Full stop. However, at the instance of respondent number 4, the said interim order passed on 10/4/2024 was vacated by another order dated 22/4/2024. Full stop. Next para. Learned counsel submits that thereafter several directions were issued to the respondents to give a posting to the petitioner. Full stop. Finally, today a submission has been made by the learned government advocate that postings have been given to the petitioner. Full stop. Therefore, learned counsel for the petitioner submits that appropriate directions may be given to the respondent authorities to treat the period between 22/4/2024 and this date.
Till the date of the order, 24/10 we posted.
Or the date of the order of posting to be given to the petitioner. As regularized in view of the circumstances narrated herein above. Full stop. Next para. The submissions of the learned government advocate is placed on record. Full stop. We expect that the formal order of postings shall be given to the petitioner in a day or two. Full stop. Accordingly, the writ petition stands disposed of, directing the respondent authorities that the period between 22/4/2024 and the date when orders of postings are given to the petitioner as regularized, having regard to the facts narrated herein above. Full stop. Ordered accordingly.
Great.
There's only one submission I appear for the contesting respondent. My presence may be noted. That's
Yes, it will be noted.
yes, sir.
Serial number 45. Interim order.
Interim order.
Please, Your Lordship.
45 will interim order stands.
56 lots, 56. On behalf of Manvinder Reddy lots, I seek for one short foundation. Inform the other side as well.
56, informed illappa, they have to be here.
That
They
I
are-
am
they
here.
are here.
No objection.
56. At the request of learned counsel for the appellant.
Yes.
Huh?
Yes.
Release this matter
12th, my lord.
on 6th of November.
Please.
My lords, one humble submission, my lords.
Yes.
Serial number 48, my lords. I'm appearing for the appellant, my lords. A week time may be granted, my lords. We'll address the arguments, my lords.
In this case, I am for R3.
Ah.
A date may be fixed, my lordship, since from 2014.
Serial number 48. At the request of learned counsel for the appellant, release this matter on 13th of November.
Please, my lords, much obliged, my lords.
37, man. My colleague is here. Pass over. It was passed over, my lord. I request for Monday.
Monday ka tha.
I am having personal inquiries. I am going out.
Serial number
37.
37. At the request of learned counsel for the appellant,
Petitioner.
petitioner, release this matter
Monday.
on 5th of November, Tuesday.
Stay experts.
In
Stay experts. Stay experts. today.
interim order granted earlier stands extended till the next date.
Thank you.
Done.
Listen, Your Lordship. Serial number 50, I appear for the appellant, Your Lordships. I have informed the respondent he is appearing in VC, Your Lordships. He's appearing in the Bangalore bench matter in the VC. I told him I will seek for an adjournment in that matter. Kindly have it next week, Your Lordships.
Not there now.
No, Your Lordships. He's appearing in other matter before the Bangalore bench, Your Lordship. There is no other office colleague for him to be present before this court.
Anyway, we'll adjourn.
Please, Your Lordship.
When the matter reaches, we'll adjourn.
Please, Your Lordship.
Yes.
Obliged.
Serial number 47, Ashokar Kalyan Shetty.
Kindly pass over, man. Kindly pass over. He is held up in fifth quarter 5.
ಯಾರು
Hamda.
ಬರ್ತಾರಂತ
ಹಾ.
ಇಲ್ಲಿ ಗೌರ್ಮೆಂಟ್
ಮಂಡೇ ಮಿನಿಟ್ಸ್
ಹಾ
ಮಂಡೇ
ನೀವ್ ಯಾರ ಪರವಾಗಿ
ಗೌರ್ಮೆಂಟ್
ಗೌರ್ಮೆಂಟಾ he is not available today.
some due to the some personal inconvenience he has gone.
He has
native
left.
Basras.
Serial number 47 at the request of the learned government advocate release this matter.
PGS.
On 7th of November.
Please.
Serial number 50, RS Siddhapurkar.
The request of learned counsel for the appellant. Huh? When do you want?
Next week, Your Lordship, any day.
Release this matter on 7th.
Please.
On 7th of November.
Obliged.
Serial number 51, DP Ambedkar.
Matter is called out. There is no representation for either of the parties. Release this matter on 12th of November.
Serial number 52, J. Agustin.
Matter is called out. There is no representation for the appellant. Release this matter on 11th of November.
Serial number 53, Ashok Patil.
State 53.
53.
Our notice ತಗೊಳ್ಳಕ್ಕೆ ಆರ್ಡರ್ ಆಗಿಲ್ವಲ್ರಿ ಸ್ಟೇಟ್ ಆಫ್ ಕರ್ನಾಟಕ ಬೈ ಡೆಪ್ಟಿ ಕಮಿಷನರ್ ಹಾ
ಇಲ್ಲ
ಸರ್ವ್ಡ್ matter is called out. There is no representation for the appellant. Stop. Nevertheless, learned counsel for the appellant is also directed. Learned government advocate is directed to take notice for respond number 2. Huh?
Yes.
Learned counsel for the appellant is directed to serve copy of the appeal memo on the learned government advocate.
Serial number 54, additional SPP.
It's a state appeal, my lords. 307 and 366. That side is no.
Matter is called out. There is no representation for the respondent. Release this matter on 13th of November.
Serial number 55, additional SPP.
Yes, Mr. Mantesh M. Desai, Mantesh H. Desai,
Respond number 1 to 3.
same order. 13th.
Serial number 57, Vishal Pratap Singh.
It's a conviction.
Matter is called out. There is no representation for the appellant. Release this matter on 19th of November.
Serial number 58, Sanjeev Kumar C. Patil. Serial number 58.
Kindly pass over. Pass over.
No passover. No. You are for the respondent.
Yes, sir.
Which respondent?
The first is.
Respond number 1, Mr. Ravi B. Patil.
Yes.
Matter is called out. There is no representation for the appellant. Release this matter on 19th of September. Sorry, November.
CL number 59, Ravindra Reddy.
Two thousand nineteen, my lord,
ಇವ್ರು ಏನ್ ಬರೋದೇ ಇಲ್ಲ ಇವರು ರವೀಂದ್ರ ರೆಡ್ಡಿ ಅವರು. At the request of learned counsel for the appellant, release this matter on 11th of November.
please.
CL number 60, Manvendra Reddy.
Matter is called out. There is no representation for either of the parties. Release this matter on 12th of November. Pass over ಮಾಡಿದ್ವಲ್ಲ ಕೆಲವು ಇಲ್ವಾ ಆಯ್ತಾ?
ಹನ್ನೆರಡು 11.
ಸರ್ ಎಷ್ಟಂದ್ರೆ 12. ಭಾಳ ಸ್ಪೀಡ್ ಇದು ಮಾಡ್ಬಿಟ್ಟಾರೇನು ಸರ್? ಅದೇ ಮಧ್ಯಾಹ್ನ ಇದ್ದಿದ್ದಿಲ್ಲ ಒಮ್ಮೆ ಬಂದ್ ಹಿಂಗ್ ಹೋಗಿಬಿಟ್ಟಾರ ಸೀದಾ ಎಲ್ಲ ಡೇಟ್ ಕೊಡೋಣ.
ಯಪ್ಪ, ನಿನ್ನ serial number 60 ಯಾವ? ನೀರು 60 ನೋಡಿ, 6 ಅಂತ ಬರ್ಕೊಂಡಿದೆ. ಈ ಸಾವಿರ ಅದನ್ನ ಕೇಳಿದ್ರು.
ಕೊಡ್ಲಿಲ್ವಾ?
After 6.